Good?
Try it now.
Can you mute it?
I'm not sure how to do it.
Well, we can just, oh, no, turn your volume down.
I did that.
So next to the mute button, there's a chevron. If you open that up, it should give you the option to leave computer audio.
Just go back to the Zoom, so. Back to the Zoom, so that we're watching.
Oh, Representative Peter Bixby?
Yes.
Welcome
Are
aboard.
we-
Oh, we haven't started. I just introduced you. Welcome aboard for the day. Issues to filling in the email.
Oh, who's filling in for the representative? Hey, Walters.
Representative Peter
Bixby.
Ready?
Let's still somebody.
Did you want me to have IT come down and help out?
Whose device?
Representative Morrison said that he's on mute.
Good, he's muted, but his volume is on.
And I would think it's all the way down. Someone else wanted to take a look. I was on sound for him. And
Representative Burke.
It's gotta be muted, not just.
You need to turn off the speaker. I'll take a look at it, Representative Marston, if you don't mind.
I turned the whole thing off.
We're getting worse.
I turned it completely off.
It's off completely?
Casey's coming in?
Okay.
So it shouldn't be me.
It shouldn't be.
Be a little late, but he'll be here.
All right, we can hear you just fine now.
Sounds like we've got it solved there. If you decide you need to use it again, Rep. Marston, I'll take a look at how to turn the speaker off for you.
Yeah.
We good?
All
right.
After this hearing, we can do it.
All right, you're all set to go. Recording has begun.
Morning. As the chair of the House Criminal Justice and Public Safety Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing with the potential for executive sessions to be held throughout. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during the meeting through Zoom electronic meeting platform. And the public has access to contemporaneously listen and if necessary, participate in a meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the general court website. The notice for this meeting complies with House rules and RSA 91-A. Anyone who has a problem assessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. I want to introduce the staff that are on the meeting today assisting us. It's actually not Brad Greenland, it's Christine Dyer. Please note that all votes that are taken during this meeting shall be done by roll call vote. Let's start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there's anyone in the room with you during the meeting. It is required under the right to know. Madam Clerk, will you please take the roll.
Vice Chairman Welch,
I'm here with a bunch of Republicans and a Democrat.
Representative Burt,
I am here in committee.
Representative Spillane,
I am here in the committee room.
Representative Green,
Here.
Representative Wallace,
Present.
Representative Testerman,
Here.
Representative True,
Present in the committee room.
Representative Pratt,
Yeah.
Representative Marston,
Here.
the clerk is present. Representative Harry Gattray,
Present in the committee room.
Representative Bixby,
I'm present, and I am in my home office in Dover, New Hampshire, and I am alone.
Representative O'Hearn,
Present alone.
Representative Bordenay,
Here alone.
Representative Hughes,
Here and alone in my home office.
Representative Newman,
Here and alone.
Representative Bolden,
Here and I'm at home.
Representative Conley, Representative Klein Knight,
I'm here and I'm at home and my sister's in another room.
Representative Bradley,
Here and my daughters are with me.
Chairman.
The chair is present in the room.
Mr. Chairman, we are just waiting for Representative Conley.
I understand he will be arriving around 9:30 today, so we'll make sure we note the record when he arrives.
Yes.
At this time, we will now open the public hearing on House Bill 539 relative to.
Mr. Chairman,
Oh, thank you, Representative Marston. Representative Marston, will you please lead us in the pledge of allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
This time, the public hearing is open for House Bill 539 relative to records of communication common carriers. Is the sponsor
Yes.
here to introduce the bill?
Yes, he is. Mr. Chairman, would you like me to allow him to talk?
Yes. Yep, Representative Joshua Kelly, you're recognized to introduce House Bill 539.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Representative Joshua Keller, representing Brentwood, Danville, and Fremont. I come to you today to introduce and ask for your support of my bill HB 539. RSA 7:6-B allows the AG to demand customer data of communication common carriers without a search warrant. And I want to bring this law in line with our new constitutional amendment, Article 2B, and ensure that a warrant for customer data is required. You have heard bills like HB 597, which seeks to bar information like this from the government agencies without search warrants. And I want to close this loophole if such other bills were passed also. This law was passed in 2001. And since then, we have learned that the government has used many avenues to get citizens' personal data. Article 2B was proposed and passed with overwhelming support to help address the government overreach. And this law specifically states that customer information from your telephone and internet companies must be handed over to the government upon request and without a search warrant. I asked the AG's office for how many of these requests have gone out since we amended our constitution, and they turned that into 91A requests. So they will get back to me by April 9th. So I can't tell you the scope of the issue currently, but its effects are still being had even if it's not being actively used. My example of this is the law is cited in State v. Mello, which the Supreme Court let evidence stand, which was obtained based on a warrant for which the warrant was later thrown out. And the court effectively said that the information could be obtained without a warrant, so no warrant was required, essentially opening this information up to any agency, as it wasn't the AG that got the warrant in the case that they were talking about. So as the legislature fleshes out what the information and personal information is protected under Article 2B, I ask that you protect, the customer's names and addresses and billing records and more, and close this loophole to our government to gather private information without a warrant. And I thank you and am happy to answer any questions.
Representative, thank you for your testimony. Representative Bourdonnais, you're recognized for a question.
Thank you, Mr. Chairman. Thank you for taking my question. Today, it requires the written demand of the Attorney General to request this information, which seems like it would be more difficult to get than a search warrant. Search warrants are routinely given by telephone. Is this not the case?
So the question of whether it's easier or not, I would go towards what is the standard for such a request. So in search warrants, I would say that the standard is probable cause, whereas a demand, the Attorney General just needs reasonable grounds. So I think that's a lower standard to reach. And so that is my focus of not necessarily whether it can be handled by a phone call or whether it needs to be a written demand, but the standard that is used and the hurdle that or the standard which the government might use to be able to get that customer information. So thank you for the question.
Thank you.
Thank you, Representative. Representative, if the chair could inquire a question, and I want to thank you in advance for taking my question. Can you answer this, whether does a common carrier of the communications common carrier, do they have, absent a search warrant, can they refuse the request of the Attorney General?
So no, this is a shall. They have to give. So in it says shall furnish to the Attorney General. So there is no refusal if the Attorney General asks.
Thank you. Representative Burt, you are recognized for a question.
Thank you, Mr. Chairman, and thank you, Representative, for your testimony. If I'm understanding correctly, this bill is only for, my home phone or cellular service, not social media or Google searches. Is that correct?
Thank you for the question. So common carrier is defined in the referenced RSA, and I don't believe that it would. So let me just read the definition. A person engaging in or providing communication services to the general public through transmission of any form of information between subscribers by means of wire, cable, radio, or electromagnetic transmission, optical or fiber transmission, or other means which transfers information without physical transfer of a medium, whether to be switched or dedicated facilities. And then it carves out radio and television broadcast or any other general distribution of form of communication shall not be deemed communication carrier. So based on my reading of that, technically you are giving you are transferring information between people, probably via optical or fiber optic transmission, since that's what we're using to send stuff through the internet. So I think that it might be encompassing social media.
All right, thank you.
Representative Spillane, you recognized for a question.
Thank you, Mr. Chair, and I thank the member for taking my question. Can you tell me what in my understanding of this is currently only the AG that can make this request, which would mean that the AG is typically only handling criminal things. can you tell me if there's bleed through with a warrant that would open this to civil actions? And then also open up such avenues as civil actions within family courts, divorce proceedings, and the like?
Thank you for the question. So in the RSA, the AG can designate both the county attorneys and in certain RSAs to enforce certain RSAs, and the assistant AG to be able to make such demands also. The bleed through that I'm seeing to other agencies is the Supreme Court ruling that if you can get this information without a search warrant, that the law enforcement agency, which is not the AG, was able to essentially have this information without a warrant introduced into a case. And so that's kind of bleeding the line of it just is the AG to pretty much anyone else that is a law enforcement agency. I don't think I have any evidence that it's bled all the way into civil cases, though.
Follow up.
Ms. Swain, you recognize for a follow-up question?
Thank you, Mr. Chair. So under current law, in a civil action such as a small claims action, say a builder who's taking action against somebody who refused to pay or what have you, any of that would not be accessible. A builder could not, as part of his small claims action, demand that the cell phone records and media records of the person that they're suing be turned over to them. By lowering this to a warrant standard, then if the small claims court, the lower court, decided that a warrant was appropriate, and they gave a warrant, they could actually demand all the electronic records from somebody in something as simple as a small claims case or even in a divorce case or the like. Is that not true?
Thank you for the question. I don't believe this opens up any additional avenues, because currently if a judge wants to grant a search warrant for these companies, that would still be honored. So it's currently allowed. It's just for people to be subject to search warrants. So I think it's only making sure that something below reasonable suspicion or the requirements of a search warrant are met. So right now, it's the AG just needs to have a suspicion of something that might have been criminal happening. And so for the demand, whereas reasonable doubt has a higher standard. So thank you for the question.
Representative Muse, you're recognized.
Yes, thank you for taking my question. I'm wondering how your bill addresses location data and potentially things like real-time pinging by police officers, which are requests that will come to carriers.
Thank you for the question. We actually have another law that deals with information data, but this bill does not address that, as it is not. So the bill actually, or the RSA lists a specific number of things that the people can request, and location data isn't one of them. So I don't believe that it's within the scope of this RSA. I think it's in a different RSA, but thank you for the question.
Thank you.
Representative Newman, you're recognized.
Thank you, Mr. Chair, and thank you to the witness for taking my question. Would this have any effect on when I read an article trying to figure out what this bill meant? It talked about geofencing, where they get megadata within a specific geographic area, like they're doing on the insurrection at the Capitol. Would this have any effect on the gathering of that kind of information that originally is only the location, and then based on that they get, I'm not sure whether they have to get a search warrant or not to get the additional information like that. Would this affect that particular activity?
So since this was is very similar to the last question on what is covered. So in the RSA, it says that they shall furnish names, addresses of persons who are stated, listed, or unlisted, telephone numbers, phones and addresses of anyone with an identified service, anyone, any local or long distance billing records, telephone customer service records, the length of the service provided, the types of services, telephone numbers. So I think this is really focused on trying to get people's telephone numbers and other subscriber like billing records. I don't think that it's not specifically mentioned like geofencing or location data, and that is specifically addressed in RSA 644A, I believe, the regulations around location data. And so I think that I think it's probably outside of the scope of this, as it doesn't specifically carve out exception to 644A. Thank you for the question.
Thank you.
Representative Gathright?
Thank you, Mr. Chair. Thank you for taking my question. If this became law, this bill, what impact would have had on getting the records of the insurrection that happened down in at the Capitol?
Thank you for the question. I believe this was very similar to the last question. Nothing, I don't believe. No, this is so I just described the types of things and that would be covered under this, and location data is governed by a different RSA. But thank you for the question.
Thank you.
Senator Newman, your hand is raised. Do you have another question? Representative Newman, your hand is raised. No question. Seeing no further hands raised, I want to thank the representative for his testimony. Oh, excuse me, Representative True.
Thank you, Mr. Chair. Thank you for taking my question. Could you give me some examples of what information on my phones somebody would want that they don't have access to already? Just concrete examples of what information somebody would be asking for.
Thank you for the question. So in the case of the State v. Mello, they were asking for, essentially they had an IP address, and they were asking for, the name, address, phone number, et cetera, of that person based on the IP address. So like the same thing would be like if they had your telephone number, if you called someone and the AG or whoever law enforcement agency was trying to track down who this phone number belongs to, they would try and go to a specific agency and say, okay, give me all of the records that you have for this phone number, kind of a thing. And so they would be getting that data that way. Does that answer your question?
Yes, thank you.
Thank you.
Seeing no further hands raised, I want to again thank the representative for his testimony. The witness is excused. For any members of the public who wish to testify, that are in attendance, please raise your hand at this time. For the purposes of this hearing, testimony will be limited to 2 minutes per witness. The chair now recognizes Penny Dean.
Whoops, thank you very much, Chairman. My name is Penny Dean. I'm an attorney, and I believe there's rampant abuse of this. This is basically a fishing expedition license for the Attorney General and his designees. And to answer the question about what information, imagine any of us that has a smartphone and handing it to someone else and allow them to fish through it to see the telephone numbers you called, the amount of time you talked to them, the frequency at which you talked to them, the numbers you called, your text messages, your emails, what you searched, and at least my concern always is in general, but for gun owners, if you want to see who gun owners are talking to, who the other gun owners are, what gun shops I'm calling maybe to buy firearms, that is a real problem. And right now, there is absolutely no basis for the Attorney General as a practical matter, restricting them from asking for this information. When they send a request over, the common carriers click their heels and hand it to them on a silver platter. And that is simply not right. It's, in my mind, a Fourth Amendment violation. And the carriers are complicit because they're afraid of government regulation. And so, or abuse, if you will, of regulation. Passing a law like this is going to give us a little bit of protection and making the Attorney General's office or their designee go before, in theory, a neutral and detached magistrate that has to have an affidavit signed under oath. And so one of the representatives that asked that this would be lowering the standards, absolutely not. This is protection. I see this as raising the standards. And I see this as making an example that they cannot simply get around the Constitution by laws like this, which is really what's been happening. And it's unfortunate. And so the bottom line is, if they think someone's breaking the law, if they have probable cause or any type of basis, they should be able to put it in an affidavit where an officer has to sign under oath under the pains and penalties of perjury. Not just I think or maybe baby. I have this information that I'm.
Chairman, I have a question. The witness is over 2 minutes.
You're out of order. You were not recognized to speak. Please don't interrupt the testimony of the witness. Although testimony for members of the public is limited to 2 minutes, it is within the discretion of the chair to allow it to go beyond that. You are the first, and it's been like that throughout the entire term. You're the first person, member of this committee to complain about that. So please, if you wish to speak, you must raise your hand and be recognized. I apologize to the member of the public testifying. You may continue your testimony.
Thank you, Chairman. So I see this as being more protective for consumers and more protective in general, because I will be surprised if the Attorney General on April 9th, at the conclusion of when the representative's right to know request truly responds with complete information. I think the committee should look at what the response is and then talk to the criminal defense bar and suggest that I'll be shocked if all the information is given. I think that what you're going to see is the Attorney General is going to claim there's ongoing investigations that this would compromise. I don't believe that will be accurate, but I think that will be one of their grounds for not giving all complete information under 91A. So I'd respectfully say that even if a person isn't a gun owner, I don't care if you're a dog owner or a whatever you are, you don't want your entire circle of friends being identified by name and number and being harassed.
If you don't mind suspended, we do have to limit, come to testimony to.
Oh, thank you. I apologize. I'll wrap up. I would respectfully ask the committee to pass this bill. I think it's a good bill, and I'm happy to answer any questions. And thank you, Speaker or Chairman.
I want to thank you for your testimony. And if the chair could inquire of a question, and I want to thank you in advance for taking my question. In regards to the communications of the data that we're referencing, my question is who owns that data? And what I'm getting at is, I understand there's a problem here. My question is, would a warrant be the resolution that, because the common carrier is a third party?
Thank you for your question. The common carrier is a third party, and I can't say that I've seen every cell phone or common carrier agreement, but I, like everyone else, have switched carriers over the years. Every carrier that I've ever signed the agreement with, nobody reads the agreement except for geeky lawyers like me. And it provides that the carrier owns the data, at least the ones that I've looked at. And so I can't imagine that all the others don't provide the same thing. But even though they own the data, and so you normally say, well, that's not a Fourth Amendment violation. When the data is being coerced, which essentially is by the AG, the person doesn't even know their data has been accessed. And that's what's really troubling. Because if I knew that, let's say, Verizon gave my data up to the AG, I might switch to a different carrier. And I might want to know what had been given to the AG and why. And so they have an incredible amount of data. The other thing is when private attorneys will subpoena, like for example, I would subpoena phone records. I do it all the time. It's amazing. The common carriers will tell me, oh, we don't have it past 30 days or 60 days or whatever their arbitrary limit is at a given time. Yet if the cops go get it, they can get it for years back. So the common carriers do not treat defense attorneys the same way they do the prosecutors. And that's a problem. And most clients, you can't afford, the average client cannot afford to litigate against Verizon or AT&T. They're a monster, you know?
Thank you. And if I may take my question, if I may inquire of a follow-up question. So would you believe, or would you agree that it's a potential Fourth Amendment violation to require the common carriers to surrender the information or the data without the requiring of a warrant? I mean, I suppose if AT&T or Verizon wanted to decline a request made by the Attorney General's office, if they don't need a warrant, they basically have to surrender it.
They do have to surrender it right now. And a lot of them are afraid not to. Unfortunately, the people in black robes, because AT&T is not a government entity or the common carriers are not a government entity, they don't see it as a Fourth Amendment violation. I do. But here's what I remind people. Until Heller came down, the black robes in this country didn't say we had an individual right to keep and bear arms. It wasn't until Heller and McDonald that the court recognized that right. So courts are not always right, but I agree that it is a Fourth Amendment violation, Chairman, but I don't think all the courts do.
Thank you again for taking my question. Representative Burt, you're recognized for a question.
Thank you, Mr. Chairman, and if I may also, be recognized in a minute for a follow-up. But my first question, Attorney Dean, is you've already answered part of it, that they can subpoena my records, or not subpoena, they can, the AG can request and get my records or anybody's records from Verizon, who I'm with, or any other carrier. Is there a way that I could find if that has been done? Or is it a secret that I will never know?
It is a secret. I would be shocked if you're able to find that out, because law enforcement always puts this caveat in that this is a law enforcement matter and you could compromise an investigation and blah, blah, blah. So I have had clients that we know their records were obtained by law enforcement because we got them in discovery. And when they called their carrier's like, we don't know what you're talking about. And all I could think of is liar, liar, pants on fire. But you can't make them give you that information. So I would say, I would be shocked if you found out.
Thank you. And follow up, Mr. Chairman.
Representative Burt, you are recognized for a follow-up question.
Thank you, Mr. Chairman. And thank you for taking my follow-up question. As I read the bill, it's obvious. It's for cell phones, landlines, et cetera, like that. But does it also include social media, Facebook, and Google searches? Would it incorporate that?
Thank you for your question, Representative. I think it would if it's used from your smartphone, because data is data. So in other words, if you take most people's smartphone that I've ever seen, they have an internet connection on it and they run all sorts of searches through that phone, and it's all through your phone service that is run. So I cannot imagine that it wouldn't include that. I can't say how each company keeps their data, but I cannot imagine it wouldn't be part and parcel of that. And so, for example, you take someone like me, depending on what case I'm working on, there was a 2-year period where I did a lot of research on hand grenades. Now, hand grenades, if you file a Form 4, are perfectly lawful to own. In my case, I was doing research on them because of a case, not because I wanted to do anything illegal. But I do, through intellectual curiosity and through my practice, a lot of searches that someone may take umbrage at or suggest, oh, she must be looking to break the law.
All right, thank you.
Thank you.
Seeing no hands raised, I want to thank the witness for her testimony.
Thank you for having me.
There is a member of the public with a hand raised. It's only a phone number, so just please identify yourself for the record by stating your full name, where you're from, and whether you're testifying in support or in opposition to House Bill 539.
Good morning.
Morning.
This is Jay Simpkin, 20 Cabot Drive, Nashua, New Hampshire. I hope this bill will be enacted, and thank you, Mr. Chairman and members of the committee, for hearing my testimony. I'm an international economic consultant, so I think of data as a plural, not a singular. Key point is this: data are lethal. The idea that data and data security is about privacy is simply wrong. A recent example from the wider world, early in January 2020, an Iranian general arrived at the airport in Baghdad, Iraq. He got into his car to leave and was then killed by 2 drone-fired missiles. What has this to do with common carriers in New Hampshire? It is this. The only thing that the United States needed to know was where that Iranian general would be and when he would be there. Our telephones, smartphones at any rate, regularly ping cell towers so that if a call comes in, it will be clear how it should be routed. That information, called cell site locator information, is for individuals the equivalent of law enforcement putting a GPS device on a vehicle to track it. In order to put such a device on a vehicle, law enforcement have to get a search warrant. Why? Because they are seeking information that is private about a person. So they have to go to a judge or a magistrate, show that they have probable cause to need to emplace a GPS tracking device on a vehicle. And if the judge or magistrate is persuaded that probable cause has been shown, basically the warrant issues and the device can be lawfully emplaced and the person tracked. As things now stand, every one of us carries with us a GPS tracking device. It's called a smartphone. And unless we turn it off so it cannot ping cell towers, those who have CSLI, cell site locator information, which all the carriers necessarily have and have to have, can provide a map of where we go. And it's a fairly precise map. Not down to the nearest foot, but if a crime were committed, it would tell law enforcement that we were pretty close to where that crime was committed. So in short, the data that this bill would protect by requiring law enforcement to get a warrant in order to access the data is simply vital. And there should really not be, or there should not need to be, discussion as to the necessity of enacting this bill. If law enforcement needs a warrant to emplace a GPS tracker on a vehicle, they should need to get a warrant to get the information about our smartphone usage. It's really cut and dried. As the British say, when something is obvious, it is, quote, a no-brainer, end quote. Thank you, Mr. Chairman and members of the committee. I will be happy to take questions.
Seeing no hands raised, I want to thank the witness for his testimony. If there are any members of the public who are in attendance that wish to testify that have not testified already, please raise your hand at this time. Seeing no hands raised, at this time, we will close the public hearing on House Bill 539. Representative Muse, will you do the honors?
On House Bill 539, there were 9 people who signed in support. No one signed in opposition, and 2 people signed in as neutral.
Thank you, Representative Muse. This time we are opening the public hearing on House Bill 612 relative to the penalty for overtaking a school bus. At this time, the chair will recognize Representative Laura Telerski.
I would just like to recognize Representative Conley.
And may the record reflect that Representative Conley is now present and in the room. Representative, you're recognized to introduce House Bill 612.
Thank you. Morning. Thank you for having me. My name is Laura Telerski, and I represent Hillsborough 35, which is Nashua's Ward 8. Today, I'm presenting to you for your consideration HB 612 FN relative to the penalty for overtaking a school bus. A little history on how this bill came about. Back in 2018, there were a number of well-publicized accidents involving school buses. And in 2019, House Transportation received 3 different bills from both sides of the aisle that were filed to increase the penalty for overtaking a bus. The bills either increased the fines, suspended the driver's license, or were a combination of both. We retained the bills, and our full committee worked together in a bipartisan collaboration to review and develop one that we all agreed with. Today's bill, House Bill 612, is the exact same wording as House Bill 626 that passed the full House last January. Let me walk you through the changes to the statute. The current fine for a first-time offense is $150, and this bill increases it to $250. Most violations are issued to first-time offenders, and I imagine it's often a wake-up call and a lesson learned. In 2019, the Department of Safety issued 119 citations for first-time violations and 1 for a subsequent offense. In 2020, with far fewer buses on the roads due to the pandemic, there were only 38 first-time violations. However, there was still 1 citation issued for a subsequent offense. For subsequent offenses, the current statute has a range for a fine of $250 to $1,000. We heard testimony from the department that having a range is problematic, and it's preferable to have 1 set fine. We set that new fine for a subsequent offense at $500 plus penalty assessment, which is not currently included in the statute. Regarding a suspension of license, we changed the word may to shall to ensure an automatic loss of driving privilege for 30 days. Again, the department stated a preference for definitive wording as opposed to leaving suspension open as a possibility. The threat of an automatic loss of license would hopefully be a strong deterrent for the driver who receives a citation for the first offense. Finally, regarding the fiscal note of $155,000, I reached out to the department to confirm that this is the blanket fiscal note that they give to bills that would require an update to the uniform fine schedule and reprogramming of their systems. With the effective date of January 1, it can be assumed that all updates for the year would occur at once, and they would be able to consolidate all of the changes and charges at that time. In conclusion, HB 612 tightens up the wording of the existing statute while increasing the fine moderately for the first offense and a mandatory 30-day loss of license for repeat offenders. I believe these changes speak to the seriousness of the violation without being overly burdensome for the first-time offender who truly does make a mistake in passing a school bus. At the same time, one accident is far too many, and I believe the penalty needs to be updated to send a strong message about the safety of our children. I believe representatives from the Department of Safety will make themselves available after my testimony, but I'm happy to take any questions you may have.
Representative Gathright, you're recognized.
Thank you, Mr. Chair. Thank you, representatives, for taking my question. In 2020, the 38 first cases, is that just national or is that statewide?
Thank you for the question. That's statewide. I got those numbers from the Department of Safety directly.
Thank you.
Representative Muse, you're recognized.
Yes, thank you for taking my question. In the bill, the bill for subsequent offenses cites a $500 plus penalty assessment. What is a penalty assessment in terms of this particular bill?
Thank you for the question, Representative Muse. I may defer for the legal definition to someone from the Department of Safety, but what I understand is it's a additional fine that's issued. It's a percentage of the fine that is added on for the violator. And as you can see, for the first time offense in the statute, it's already listed there, the penalty assessment. I believe for the secondary offense, it was an omission that should have been included. But again, I would defer. I think Ms. Brittany Shute from the Department of Safety may be willing to answer that question if she's in attendance.
Thank you.
Seeing no further hands raised, Representative, I want to thank you for your testimony.
Thank you so very much. Have a good day.
Mr. Chairman, I do not see anything else.
I know Representative Abramson is present, and he's on the list as well.
Oh, there's a couple hands, Mr. Chairman.
Any members of the public who are present and that are in attendance that wish to testify, please raise your hand this time. The chair now recognizes Representative Max Abramson. And to the members of the public, with the exception of the representative who introduces the bill, we are limiting testimony to 2 minutes per witness.
Can you folks hear me?
Yes, we can hear you.
All right, I'm Representative Max Abramson. I'll try to keep my statements down to 2 minutes. I do support the bill, and I submitted an amendment 443H, which would quadruple speeding fines while someone is overtaking a school bus or passing a school bus. My reasoning for supporting the bill, and the reason I submitted an amendment, is the fines actually seem pretty slight. This driving past a school bus that's loading and offloading children, and especially if people are driving at very high speeds, which they often tend to do, is that if you compare this to drinking and driving, this, if somebody's driving, down a dark road somewhere, this is many, many times more dangerous than drinking and driving. This is much more dangerous than somebody shooting some fireworks off into a residential neighborhood or even firing a gun into the forest or something. This is the statistics on hitting an adult. If you're driving a car and you hit an adult pedestrian, their chances of surviving at 15 miles an hour at the time of impact are about 85 to 90%. If you hit them at 25 miles per hour, that drops down to 55%. And if you hit them at 35 miles an hour, there are American and European studies that show the survival rate drops down to about 10 or 15%. And most civil engineers and safety experts admit that at speeds higher than that, your chances of survival, if you get hit at a speed higher than that, are almost none. So when a school bus stops, it's almost certain, and they put the stop sign out, it's almost certain that there are going to be children going across the road. It's almost a certainty. And so somebody speeding past a bus, their chances of hitting a child are very, very high. And that child doesn't have any realistic opportunity to move out of the way. The visibility is very poor. It's why we have the stop sign up. And there's nothing that the school bus driver can do. So I think that the bill is necessary, and I also think that the amendment is necessary, quadrupling the speeding fines to deter people from flying past at very high speeds. There are some people who are driving, I've been told 70 miles an hour, but I have a hard time believing that. But even if somebody's doing 45 or 55 miles an hour past a school bus, I think that's just, that's borderline felony endangerment.
Thank you, Representative. Seeing no hands raised, Representative, I want to thank you for your testimony.
Thank you.
Oh, excuse me, sorry, Representative True.
A question of the chair.
Yes.
Do we have anyone from DMV, maybe by the name of Chris, who will be testifying, do you know?
I don't see anyone in attendance with that name or anyone on the list. There is.
Mr. Chairman, Ms. Shute is representing DMV is my recollection. And Sergeant Kelby has also addressed this issue before transportation in the past.
Thank you, Representative Conley. Again, seeing no questions for the witness, Representative Abramson is excused. At this time, the chair will recognize Brittany Shute.
Good morning. My name is Brittany Shute, and I am a representative of financial responsibility from the Division of Motor Vehicles. We appreciate the work that has been done on this bill, and as Representative Tulerski pointed out, it gives more definite suspension time and fees. With that, I am happy to take any questions.
Representative True, you're recognized.
Thank you, Mr. Chair, and thank you for taking my question. The bill addresses repeat offenders. Could you give us an idea of how many repeat offenders do not lose their license?
Thank you for your question. Repeat offenders, I cannot speak to how many have been suspended. I can definitely find that information for you.
Thank you.
Representative Pratt.
I have a question. How is the person caught doing this?
I'm sorry, can you repeat your question?
I have a question for you. How is the person caught doing this? Passing a bus and pick up the owner? You know the process? You know who calls, who turns them in?
I believe, thank you for your question. When a person passes a school bus, I believe it would be the bus driver of the vehicle or any participants witnessed, anyone that's witnessed the actions. They contact the local police department, and I believe that is how that is handled.
Will they required to write a letter? Do you think that's true? Bus drivers required to write a letter stating what they saw?
Thank you for your question. If Sergeant Kelby is on this, he may be able to speak to the process required by law enforcement to take the appropriate action and how the citation would be issued to the individual who is the offender.
Thank you. Thank you for answering.
If I may, I believe there was a question in regards to penalty assessment. The penalty assessment pursuant to RSA 106 L10 it's a penalty of $2 or 24%, whichever is graded, and is added to the fine that is set in the uniform fine schedule.
Representative Gathright.
Can you just repeat what was said?
Yes, thank you for your question. The penalty assessment is a penalty of $2 or 24%, whichever is greater, and it is applied to the statutory fine. And that would be RSA 106-L10.
Thank you. Seeing no further hands raised, the witness is excused. I want to thank you again for your testimony. At this time, the chair recognizes Sergeant Christopher Kelby.
Hello.
Hello.
We can hear you.
I apologize for, I've been having some technical issues with my computer, and as Representative Tulerski was concluding her testimony, I was finally able to get in to address the question about who is the complainant on a violation for passing a school bus. The school bus driver, or the statute actually says any witness. The school bus driver would typically be the complainant on such a violation. Of course, the problem being that the school bus driver is often, focused on the kids getting on and off the bus, and dealing with the kids that are on the bus. So a lot of times those complaints can't be prosecuted because we can't get a good statement from the driver, and often times.
Representative Conley, you're recognized.
Thank you, Mr. Chairman. Thank you, Sergeant. In your experience, do higher fines tend to lead to changes in behavior, like has been suggested might occur if this bill were to pass?
Yeah, I think that's, if you're asking my personal experience or my guess, I should say, I would say yes. Knowing that it's going to cost you X amount of money if you're speeding in a particular area is probably going to make people slow down a little more often. The possibility of a suspended license is certainly going to increase that that I would call it survivability. I know in Maine they have criminal speed. There's an assumption by a lot of motorists in New Hampshire that we have criminal speed. We don't. Obviously we have reckless driving, but the knowledge that criminal speed is out there and people can be arrested for a particular speed limit, like in Maine, does affect people's attitudes towards driving.
Representative Conley, you're recognized for a follow-up question.
Thank you, Mr. Chairman and Sergeant. Did I understand correctly a moment ago, you say that some likely cases of passing the school bus illegally are not actually prosecuted as such? This might suggest that the number of times this occurs would be more than the data of people who are penalized for this offense would suggest.
Thank you, Representative Conley. And that's not a guess. We do Operation Safe Stop. We didn't do it last year because of COVID. And it's a new initiative that school bus industry initiated with Department of Safety and the SAUs. And we're reporting, many times more violations of passing school buses than are prosecuted. And that's factual information. We take those stats, and I apologize, I don't have those stats. I wasn't prepared to answer a question like that. I can certainly look to my trooper that's in charge of people transportation to obtain that information. But the year before last, when we had Operation Safe Stop, we had, I think we issued maybe 3 or 4 summonses throughout the state. But that was just a tiny percentage of the reported violations that occurred during that particular day that we had this operation going.
Representative Pratt.
I have a question. In my area, we have a large bus company. We have one driver that writes a letter, usually almost every month, about somebody passing them. And then we have other bus drivers that never have written a letter for that violation ever. And they've been bus drivers for years. Do you think that speaks to the accuracy of the bus drivers in trying to prosecute this thing?
No, I don't. And thank you for the question. Being a cop's not easy. And being aware of all the laws that we have to be familiar with isn't easy as well. And going to court isn't easy. We present cases often and they're thrown out. But educating law enforcement as to the process under 265-54 has always been really hard for Department of Safety's People Transportation Unit. A lot of times, police officers are not aware that the law speaks to a school bus driver being able to be the mechanism for legal action to take place. Now, consequently, it's also imperative that the complainant is able to identify the vehicle that passed it. And again, this is the problem. The Office of Pupil Transportation does not get a lot of these letters. What we typically do, and I've done this in the past, is I'll get a call to my trooper that runs that program, and I'll be filling in for him, whatever the case may be. And I'll have a bus driver irate that they had a vehicle pass them. And my question is, did you get the license plate? Well, I didn't. Oh, okay. Do you have a camera on the bus? Well, we don't. Okay, can you describe the vehicle? Well, it was green. There's not a lot we can do with that, unfortunately. So a lot of times we'll get these complaints that unfortunately just aren't up to snuff for us to be able to do anything with, but also getting off track here. Getting that complaint with the accurate information to the police officer is imperative. But we also don't enforce laws in these traffic laws in most communities. We refer these to the police department. We will get calls from concerned bus drivers that the local police department isn't issuing a summons based on their complaint. We've called police officers, police chiefs from the community, and explained to them that the driver of the school bus under statutory law is essentially the complainant for that summons. Police officers are not used to that because we don't normally, most cases we can't use a complaint from a third party to prosecute. So we have it drilled in our heads that, we can't rely on a statement without a complaint affidavit and warrant to support it after an investigation. But this is one that says, oh, by the way, you don't need it. The school bus driver is sufficient. So education to the police department is essential. Reminding police officers that they have the authority to do this. Continuing with Operation Safe Stop educates our police officers too to this law. But a lot of these complaints that do go to the DMV, they don't make it to us, but a lot of times when they do make it to the police, they're not enough for us to prosecute. I hope that answered your question.
Thank you. Thank you for that answer.
Representative Buse, you're recognized for a question.
Thank you for taking my question. You raised an issue that I was curious about. I'm wondering how common cameras are on school buses in New Hampshire.
Thank you for your question. They're not statutorily mandated. And the problem, of course, is that, typically the cameras that are on school buses are inside facing cameras. And they're also owned or contracted by the SAU. The school bus company doesn't actually own the rights to that digital information. Typically, we'll have a complaint of a school bus driver come in, like behavior type issue. We'll find out if they have a camera on board, and then we'll petition the school department, the SAU, if we can gather that information. Some school bus services, like Manchester Transit Authority, have 365-degree cameras inside and outside, making a violation really easy for a police officer to bring forward on behalf of the school bus driver. But those are very rare. We don't have a lot of cameras out there. Interior cameras are more common, but they're not required by the state.
Follow up?
Representative Muse, you were recognized for a follow-up question.
So knowing that Manchester has that type of equipment already on their school buses, do they have a higher rate of prosecutions for this offense?
Thanks for your follow-up question. And of course, that's one I have no idea about. I could tell you the year before last, when we were doing Safe Stop, we were actually in Manchester, and about an hour after the operation started, our first summons issued was by Manchester, which was great. But I think we only had like maybe 3 summonses issued that day, but one of them was Manchester. I think Portsmouth was another one. But I can't answer that question without, I really don't know the answer to that question.
Thank you.
Seeing no further hands raised, I want to thank the witness for his testimony.
Thank you.
For any members of the public who are in attendance that wish to testify that have not testified already, please raise your hand. The chair now recognizes Catherine Cooper.
Thank you, Mr. Chairman and members of the committee. This is Catherine Cooper here testifying today in opposition to this bill on behalf of the New Hampshire Association of Criminal Defense Lawyers. Our opposition is fairly simple. We believe that you should leave the discretion for punishment of the bulk of offenses to prosecutors and judges so that they can evaluate the facts and circumstances of each case. I can tell you quite a few stories having represented people on charges like this where it would have been significantly unjust to punish them at a higher rate and to have these automatic fines and license suspensions. In fact, one of the cases that I had involved an actual bus driver who was charged with passing a school bus at a school because a dispatcher had told her, she was in her personal car still, go around them and go move the other bus. So the police officer who was on site saw this car go past the school bus with the stop sign on, and he kind of went ballistic on her, and she ended up charged. By the time we were able to get to court, everything was calmed down. We explained the circumstances. The dispatcher explained. The charge ended up being placed on file without a finding because the police officer was still really angry and refused to let the prosecutor completely drop it. But that would have been a situation where we have someone who actually works there, fully understands what's going on, and the people who are actually watching the safety of the children were all in the loop and knew that the kids were on the bus, and this lady just had to go past to move the other bus. Anyway, so that's just one example of the fact that we need to give the people who are involved in actual cases the ability and the authority to put into place appropriate sanctions for the facts and circumstances of each case. I'd also like to point out the fact that in the extreme cases, for example, where someone is speeding past a school bus and really endangering someone, they're likely to also be charged with reckless operation or another higher level driving offense. So there are plenty of tools there to make higher sanctions and get license suspensions for people who are really behaving in a dangerous fashion in this way. So I would encourage the committee to ITL this statute. Thank you.
Thank you, Ms. Cooper, for your testimony. The chairman inquired of a question, and I will thank you in advance for taking my question. Did I understand your testimony correctly? Did you testify that the district attorney or the county attorney would not drop the charge because the police officer wouldn't let them? I don't know if I heard that correctly or.
Yeah, the police officer felt very strongly that because the person was technically guilty of that charge, they didn't want it to just be dropped. So it ended up being placed on file without a finding.
Thank you. Representative Burt, you are recognized.
Thank you, Mr. Chairman, and thank you for taking my testimony. So from what I'm hearing is because I see in the bill on line 6, it says that the director shall, if this passes, where before current law is may. So if I'm hearing you correctly, you believe that the may should stand so that way the judge has discretion on, yes, this is a bad person that was a dummy that passed a bus, or this was an honest mistake. Is that what I'm hearing?
Exactly, Representative Burt. That's exactly our position. You should keep the discretion with the prosecutor to request it and the judge to put a suspension in place if it is indeed appropriate in any given case.
Thank you for that.
Thank you. Seeing no further hands raised, the witness is excused. I want to thank you again for your testimony.
Thank you very much.
Seeing no members of the public with their hand raised at this time, we will Representative Muse, before we close, want to do the honors?
Yes, on HB 612, we had 9 people sign in support, and we had 5 people sign in opposition.
Thank you, Representative Muse. At this time, we will close the public hearing on House Bill 612. Just have the members stay. Everyone heads up. We're going to open an executive session to try to remain in your seats.
So, Mr. Chairman?
Yeah.
You want to mention the rules?
We're going to do that once it's over.
All right, thank you, Mr. Chairman.
When we say new rules, it's more about better enforcement.
Correct. Yes. More proper.
At this time, we will reopen the executive session on House Bill 576 relative to the Victims' Compensation Fund. Members that the speaker about to speak, that was last Wednesday. And I believe Representative Rhodes wants to be recognized for his motion for reconsideration.
Yes, Mr. Chairman, I would like to open up House Bill 576 for reconsideration to.
Is there a second to that motion for reconsideration?
Second.
That is the second. Just for the members that are participating remotely, before I ask the clerk to call the roll. In regards to the House rules, A member has to be in their seat when a matter is put to question. Once the question is put, if you're not in your seat, the rules don't permit that member to return to the seat. It's also the reverse. If you're in your seat, the member's not actually permitted to leave. Under ordinary circumstances, this is a very clear rule when we're all sitting in the room together. However, when members are participating remotely, it can be a little more challenging. For the members that are not physically in the room, I would say that every time I've removed the question, I always say, seeing no further hands raised, then I say the matter will now be put to question. If your camera's not on, going forward, the chair is not going to consider that member to be in their seat. I would say for the members participating remotely, it is a good practice to leave your camera on during the executive session. I don't see that being a very difficult task to a rule to comply with. So I would ask that all members, I do my best to make sure if there are members moving around in the physical room. I'm sure the representative from Dover knows that I try to accommodate people's schedules. I don't try to take advantage of the fact that someone's simply standing, for a minute and then try to rule them not in their seat. But at the same time, we do need to keep things moving. And if we're all going to participate in the executive session, I would assume that if the members engage, that their camera would be on. And I believe that's also just from a fairness perspective, it's for the members of the public, it's appreciated. So Representative Bolden, I see the camera's not on. We're about to move the question, but I would ask that all members have their cameras on. If they're not on, although that member's name will be called, their vote will not be counted.
Is she on?
Yes. But it would be good practice to simply leave I would recommend the members leave their cameras on so there's no misunderstanding. Seeing no hands raised, the matter will now be put to question. If you are in favor of the motion for consideration, please say yay. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Welch,
Aye.
Representative Burt,
Yes.
Representative Spillane,
Yes.
Representative Green, Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yes.
Representative Pratt,
Yes.
Representative Marston.
Yes.
The clerk votes yes. Representative Harry Gaffray,
Yes.
Representative Bixby,
Yes.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
Chair votes yes.
Mr. Chair, the vote is 20 yea, 0 nay.
By a vote of 20 yeas and 0 nays, the motion for reconsideration is passed. At this time, the chair is recognizing Representative Rhodes to make a motion about to pass.
Mr. Chairman, I'd like to make a motion about to pass for House Bill 576.
I'll second.
That motion about to pass has been seconded by Representative Gaffray. Does anyone wish to speak to the motion?
Mr. Chairman, I would, Representative Harry Gaffray would like to speak on.
You yield your,
Thank you, that was the word I was
yield to
looking for.
Representative Gaffray.
I believe that we received additional information on this over the, I guess, over the weekend from letting us know where the money comes from with the AG office. So with that said, I believe that it should ought to pass.
Seeing no further hands raised, matter will now be put to question. The clerk will now call the roll. If you're in favor of the motion about to pass, please say yea. If you're opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Byrd,
Yes.
Representative Spillane,
Yes.
Representative Green, Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True, Representative Pratt,
Yes.
Representative Marston,
Yes.
clerk votes yes. Representative Harry Caffrey,
Yes,
Representative Pantelakis,
I'm Representative Bixby for subbing in for her. Yes.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Quine Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
The chair votes yes.
Mr. Chairman, the vote is 19 yea, 0 nay.
By a vote of 19 yeas and 0 nays, the motion about to pass is passed. Move to consent.
Move to consent.
Representative Rose, can you be preparing the majority report?
Yes, Mr. Chairman.
At this time, we will now close the executive session on House Bill 576.
just gonna have a question. Who was missing other than Green?
I
Representative
believe
True.
Representative True.
Oh.
Green and True both
And the committee will be in recess until 10:30 a.m.
Representative Newman should mute your mic. House Bill 179 FN and House Bill 347 FN. Recognize the prime sponsor, Representative Abbott.
Morning.
One on the top and one on the bottom.
I am Representative Darrell Abbott. And I represent Rockingham County District 8. And I am introducing both House Bill 347 and House Bill 179. Thank you. I'll start with House Bill 347. This bill was filed last year, and I believe it passed unanimously in transportation. And however, it was either tabled or did not make it out of the Senate due to the COVID-19 pandemic. What this bill would essentially do, if someone is convicted of driving with a suspended license, what would happen is for the purposes of considering whether it's a subsequent offense, in the state of New Hampshire, they only consider a conviction previously in New Hampshire. When this issue was brought to my attention, the overwhelming majority of motor vehicle infractions or motor vehicle laws, whether they're civil infractions or amount to a criminal offense, they take into consideration reasonably equivalent offenses in other jurisdictions. It's very common with drunk driving convictions, whether it's offensive speeding or whatnot. This seemed to be the only offense that was on record that did not take into consideration an out-of-state conviction. So what this would do, it was believed that this was more of an oversight when the law was passed as opposed to anything else. So this was intended specifically to make this consistent with the other laws. And then in respect to House Bill 179, this involves a negligent homicide, and it references RSA 630:3, an aggravated offense while driving while intoxicated. Basically, this involves a vehicular homicide. What it would do is that it would, right now, it would be considered a Class A felony, but it's also, the penalty is basically 7 years. It can be increased depending on some other circumstances, but what this would do, it would add it to a minimum sentence of 10 years, as opposed to right now with the lighter sentence. It also takes into consideration if the negligent homicide was a result of a driver who had prior convictions of drunk driving, and it takes into consideration whether they had one previous conviction or they had two prior convictions. I will say that drunk driving is a problem in all 50 states, and it continues to be a problem. It's not just operating under the influence of alcohol, it's also operating under the influence of any drugs or substance that would impair one's ability to drive. It's something it's a hazard that's throughout the state and I would say that someone who's committed this offense and then is already been convicted of it, and then to commit the offense again, resulting in a homicide, is a terrible tragedy that could be avoided. But unfortunately, this is intended to really raise the offense. This bill was actually filed last term. It was Senate Bill 743. It was filed by Senator Feltes. It did pass in the Senate. However, it was tabled as a result of the COVID-19 pandemic. This was a bill that I came across really by fate, just due to the title, and because it had a similar title to a bill that was in our committee last year, even though the two bills were very different. But I signed it in support of the bill, and I supported the concept, and I certainly supported what the motivation behind this bill. The bill is drafted that was Senate Bill 743, would have a title called naming it Tyler Shaw's Law. I did not include that name in this bill, but there is an amendment that is proposed that has been prepared that would add that. And sadly, Mr. Shaw was killed by a drunk driver on April 30th of 2018. And Tyler was driving on Logging Hill Road, and at the end of the exit, a drunk driver blew through a stop sign at 60 miles an hour and subsequently hit and caused him to pass away from the accident. The driver of that vehicle had 2 prior DUI convictions. They were 11 years apart, but the driver did have 2 convictions. The perpetrator got a sentence of 6 to 12 years. It was my opinion, and I sat and listened to the testimony from the senator last year when the bill was introduced in the Senate, and I agreed that it really did show a gap in the law, that we would need some enhancement in the sentences regarding aggravated DUIs or negligent homicide. For someone who is arrested and convicted of having a DUI, as part of the, if they are convicted, the post-trial probation, there's often educational classes and awareness that person would go through. Although it's presumed that anyone who's licensed to drive knows the risks and dangers of drunk driving or driving while impaired, someone who's been already convicted of this offense has been re-educated on that. So it would be, in my opinion, less acceptable for this to happen a second time. And so there's different circumstances that can invoke an elevated offense. One of them would be the blood alcohol content being double the legal limit. So right now it's 0.08. So if your blood alcohol content was 0.16 at the time of the accident, that would be an offense that can make it an aggravated offense. I will say that this is a bill that's intended to not only raise awareness, but it's also intended to try to deter the activity of driving under the influence of alcohol. And I think it's particularly important to deter repeat offenders, because anytime someone gets behind the wheel while impaired, they run the risk of causing harm to someone in this way, and it's always a dangerous act. So I would hope that this bill is considered, given consideration, and it's ought to pass. I will yield any questions for when we're in the executive session. And thank you.
Questions by committee members, seeing none? That's for sure. That's are you there?
Mr. Chairman, I just asked her to, yep, there she is, Mr. Chairman.
All right.
Good morning.
Good morning. Would you let us know which bill you are addressing?
I'm addressing Bill 179.
Thank you. You may continue.
Good morning. My name is Beth Shaw, and I support Bill 179, which would also be known as Tyler Shaw's Law. Tyler Shaw is my son. Tyler was only 20 years old when he was killed by a drunk driver in 2018. Sadly, the tragic crash that killed my son would mark the 3rd DUI conviction of the man that killed him. I ask each of you to consider this question. If your son, daughter, spouse, or parent were senselessly, brutally murdered by a person whose driving record is littered with drunk driving convictions, would you feel 6 years in prison is an adequate penalty for the death of your loved one?
Yeah.
It is important for you to know the history of the drunk driver, Joseph Leonard Jr., that killed Tyler. It is the backbone of this bill. Mr. Leonard's first DUI conviction was at the age of 17. His second DUI conviction involved a single car accident with a blood alcohol of 0.24, along with an admission that he took countless prescription pills before getting behind the wheel. He was sentenced to 12 months in prison, all of which was suspended by a New Hampshire judge. He was also required to have an interlock installed in his car. 5 months after his interlock was installed, he blew a .16 into his interlock. In November of 2017, his interlock was removed from his vehicle. A mere 6 months after his interlock was removed, he killed my son. Mr. Leonard was not coming home from a bar the night he killed Tyler. He was coming directly from work. He worked in Lebanon and he lived in Derry. He knew he had a 2-hour drive ahead of him, yet he chose to drink enough during his workday to put his blood alcohol at .16 at the time of the crash. His history of drinking and driving, endangering countless lives of New Hampshire residents, is horrifying. What I find equally horrifying is the missed opportunities by New Hampshire courts to hold Mr. Leonard accountable for his drunk driving convictions. After all, the goal of sentencing is to send a clear message of deterrence and rehabilitation. However, when New Hampshire courts allow a defense lawyer to successfully plead down the charges to a slap on the wrist, that opportunity is lost. I will always wonder if Mr. Leonard had served some time, any time, from his second conviction, would it have changed his behavior? More importantly for me, would my son be alive today? To reinforce the fact that current negligent homicide penalties are inadequate is to compare them to other penalties of crimes, none of which resulted in death. In 2019 and 2020, the following sentences were handed down in New Hampshire courtrooms. A Moulton Borough man was sentenced to 15 to 30 years for rape. A Laconia man was sentenced to 5 years for robbery. A Manchester man was sentenced to 16.5 years for assaulting and robbing someone, assisting a federal agent. A Manchester man was sentenced to an 11-year prison sentence for federal marijuana convictions. A Goffstown man was sentenced to 7.5 years for possession of a controlled drug and possession of a controlled drug with the intent to sell or dispense. And in 2020, a Manchester man was sentenced to 10 years for possessing a firearm after a felony conviction. As terrible as those crimes are, none of those crimes resulted in death. Yet the sentences are longer than that of negligent homicide. There has been some criticism of this bill that an enhanced sentence is not going to deter people from driving drunk or solve the underlying problem. That is not the purpose of Bill 179. The purpose is to adequately and appropriately sentence habitual offenders who take the life of an innocent victim. A drunk driver with multiple convictions deserves the enhancements articulated in this bill. As a mother who has made her way through the criminal justice system because her young son was killed by a drunk driver, I am urging you to support this bill. Help protect New Hampshire residents and honor those lives that were senselessly taken by a drunk driver. As a state, New Hampshire needs to step up and strengthen the drunk driving laws. Too many innocent victims are dying on New Hampshire roads. You won't see change unless you make change. And if this bill could save just one life, wouldn't it be worth it? Thank you for your time. I appreciate your consideration.
Thank you, Ms. Shaw. There are no questions from the committee. We will then, the witnesses excused. It calls Brittany Shute.
Good morning, members of the committee. I believe I checked that I did not have any testimony, but I am here should there be any questions.
You'd be limited to a 2-minute testimony, and it would be helpful if you state up front which bill you are addressing and whether you support or oppose. Continue.
Who does she represent? I think she's,
I'm with the Department of Safety Division of Motor Vehicles, and we are neutral on this. I am here as if any questions had come up, if I could help.
I'm actually going to test
179 and 347.
I guess there are no questions. Oh, Representative Burt has a question.
Thank you for taking my question and being here for that question. The last speaker that lost her son said that the person that had the I'm not sure what it is, it's a system in your truck. It blew, he got into the truck to drive it and it blew a 1.6. I'm assuming the system, you know, the whole system, you know, our court system and everything else failed us at that point. Could you explain normally what happens and why it didn't happen in this case, that he blew a 1.6 and didn't show up at his dooryard in like 3 seconds to say what's going on?
Thank you for your question. An ignition interlock device is a device in which an individual would provide a breath sample. They're at the set point, the vehicle should not start. I'm not quite sure if Ms. Shaw had articulated that the device was removed prior to that accident with the 0.16. So therefore there wouldn't have been a device in the vehicle to prevent the vehicle from being started. But what a device is supposed to do is prohibit the start of a vehicle when the breath alcohol content has reached the set point.
All right, thank you. And Mr. Chairman, a follow-up?
Yes, follow-up.
And well, thank you for taking my second question. So how, she did mention that, you know, 5 months later, I believe it was that she said that it was removed. How would that happen if you blow a 1.6 that, and you're trying to drive, I'm assuming somebody's notified. How would that interlock system be removed 5 months later with that behavior? You know, where did the system go wrong so we could try to fix it other than just this bill?
Thank you for your follow-up question. If the device was removed from the vehicle, it would have been that the individual required to have it has met their retention period for that. If they have a 12-month requirement, they can have a 6-month requirement. The requirement can be extended due to multiple violations. If Mr. Leonard had met the point to which he, that 12 months, so we'll say, for instance, in this conversation, that he was required to have it for 12 months, on the day after the 12th month, he would request for motor vehicles a review of the record. And if there's nothing that is egregious or any item there that would keep the device in the vehicle, which would ultimately be referred to the Bureau of Hearings to have a hearing with that individual, then the device is removed from the vehicle.
All right, I understand now. Thank you for helping me with that.
Absolutely.
Is there any other questions from the committee?
Yes, I have a question.
Great. Representative Newman.
Yes, Mr. Chairman, thank you, and thank you for taking my question. And this is just more of a clarification on what you just told Representative Burt. So you have an interlock device, and 5 months prior, the person blew a value that would exceed the law to start the vehicle, and the vehicle didn't start. When they reach the time limit on the interlock device, is that record of each event where they blew into the device, is that recorded and reviewed? Or when you said that they review the record, they review the violation record?
Thank you for your question. When an individual requests to have a device removed from their vehicle, the ignition interlock coordinator does a review of the violation logs. All the violation logs are kept by the provider, so there's monitoring and there's violations. If there's violations that are consistent with referring the individual to a hearing, then those violations are forwarded to the New Hampshire Hearings Bureau, who then conducts a hearing with the defendant to determine whether the device needs to stay in the vehicle and be extended. I hope that answered your question.
Follow up, Mr. Chairman?
You have a follow-up.
Yeah, in the instances that you said that what was reviewed, I guess more specifically, if in fact that 1.6 was on the device, would the person have reviewed the information on the device, and would an amount greater than 0.08 be a reason for them not to remove the device?
Thank you for your question. When the ignition interlock coordinator reviews the reports of the ignition interlock device, 0.08 violations are sent to hearings for review.
Thank you.
Thank you.
Are there any other questions from the committee?
Representative Pratt.
Representative Pratt has a question.
Yes, I have a question, if you would. The interlock system, the ignition interlock system, has there been one designed for drugs yet, or just alcohol?
Thank you for your questions. Currently, the ignition interlock device is for the breath alcohol content and would serve for alcohol.
Thank you.
Representative Wallace has a question.
Thank you, Mr. Chairman. Not a question, but for the record, I am a licensed and certified interlock installer for the Commonwealth of Massachusetts for multiple years. If the committee has any questions, I'll be more than happy to field that. Good years of experience in this.
You will be useful during the executive session.
Yes, I hope so.
Mr. Chairman, I do see Representative Knight.
Representative Klein Knight.
Thank you, Chairman. Thanks for taking my question. How many second offender do we have any on record? How many second offenders for DUIs we recorded last year?
Thank you for your question. I do not have the information available, but I can certainly look into that for you and circle back.
Follow up?
Yes, further question.
Can you further elaborate on why the department's neutral on this?
Thank you for the follow-up.
Yes.
I do not have a response.
Thank you.
All right, further questions? Seeing none, the witnesses excused, and thank you for testifying. Chair calls Christopher Casco.
Good morning, Mr. Chair. I was here viewing. I didn't sign up to speak, but I am happy to answer any questions. And while Ms. Shute was testifying, I did look into some of our hearing records pertaining to that individual, Mr. Leonard.
Are there any questions by the committee?
Mr. Chairman, what record did he look up? You know, the DWI case?
Yeah, so the one that testified.
Yes, I looked up our hearing records for interlock extension, and I do have a hearing report in front of me for what looks like a violation hearing that we held based on a 0.165 BAC that had occurred on September 23rd, 2016. So I believe that may have been the incident that Ms. Shaw was referring to. So I can tell you what the department did in that particular case.
Chairman, I would have a question.
Yes, Representative Byrd has a question.
Thank you, Mr. Chairman, and thank you for looking that up, because that, I'm just at a loss of why this happened. So if you wouldn't mind explaining why he was allowed to blow a 1.65 and then 5 months later have his interlock system removed out of the vehicle.
Yeah, we held a hearing on November 10th, 2016 for an interlock extension, because if someone is not able to start their car based on an elevated BAC, the report goes from the interlock provider to the Department of Motor Vehicles, who then forwards it to us. I'm the person generally who reviews the violation reports and recommends what to be scheduled for hearings. So this document was reviewed. It was recommended for hearing that was held on November 10th, 2016. And there was an order extending the interlock device based on that 0.165. It was for a period of 6 months. I mean, in retrospect, we can look at, was a 6-month suspension long enough? In retrospect, it probably was not, but that was the action that the department took. A hearings examiner did look at it and did extend the device 6 extra months.
And a follow-up, Mr. Chairman?
Yes, so you have a follow-up.
Thank you, Mr. Chairman. From what I understand, and please correct me if I misunderstood, it was removed 5 months later. You know, how would that happen?
Well, I would have to look at when the removal date was, but according to this, I'm looking at the hearing report, and it was effective January 3rd of 2016 for 6 months. So that would put it into July for that extension.
Any further questions for the committee? Representative Newman has a question.
Thank you, Mr. Chairman, and thank you for taking my question. The 6-month limitation on the extension of an interlock device, is that a rule or is that an RSA is that a maximum limit or is it something else?
No, for each, and that is a lesser, for each extension, it could be up to a year extension. So that's why I say in retrospect, extending it for 6 months. If we had it to do over again, maybe we would do it differently, but it can be up to a year. So the hearings examiner could do it up to a year for each test over the 0.025 BAC.
Thank you very much.
You're welcome.
Any other questions from the committee? Representative Bourdonnais has a question.
Thank you, Mr. Chairman. Thank you for taking my question. So it was clear that there are people that drive intoxicated that have real issues with alcohol. What recourses does the department have in order to try to rectify behavior of such individuals?
Thank you, Representative Bourdonnais. I think the interlock program, the extension for violations can occur. There are certain types of behaviors that can result in license suspension. So an example for a repeat offender that can be utilized is if someone keeps coming up to us for hearings because they keep testing over, the car doesn't start, we schedule them, we look at the history, we can suspend the license for a pattern of interlock failures. In terms of what a pattern is, that's really not defined in the statute, but to me, more than probably 3 is a pattern. So generally, if I see 3, 4, 5 prior hearings for interlock extensions due to tests over or some other type of violation, I will also schedule it not only for a violation to see if the device should be extended, but for a hearing to see if the license should be suspended based on a pattern of failures. Although kind of at the beginning of this program, one case that we saw, we kept seeing repeated failures for this man. And eventually his license was suspended. The interlock was removed because he wasn't supposed to be driving. He got in a car without an interlock device, got charged with a DUI. Luckily, he didn't hurt anyone, but he called our office complaining about that we suspended him, the interlock got taken out, and he was blaming us for his getting a DUI, saying, if you didn't suspend my license, I would have still had an interlock. I wouldn't have gotten a DUI, which I thought was kind of an interesting set of facts that happened in that particular case.
Other question?
Yes. So it seems like the only actions we can have are increasing the use of the interlock device. But is there no way that we can have this issue of alcoholism addressed by the individual rather than just extending the amount of time his license is suspended?
That's certainly a good point, Representative Bourdonnais, because if you don't address the underlying alcohol issue, although I think in terms of the statutes would say the requirement of completing the impaired driver care management program before license restoration addresses the alcohol issues. Although once someone has completed that program and completed all the aftercare and then they get their licenses back, they're beyond mandatory counseling, although I think your point is well taken, is what can we do in the law after someone leaves the IDCMP program successfully in order to address preventing future alcohol abuse? And that's a good question. I think maybe it's one we continue to need to work on to answer.
Thank you very much.
Glenn has a question.
Thank you, Mr. Chair. My question is very similar to the previous one, but I have a few other things that Representative Bourdonnais did not ask. My question really, it does center around cannot we at some point force a person to go through treatment for their addiction as part of the program, but tied into that, we have with the opioid addiction seen a lot of driving while impaired that takes place due to drugs that are not alcohol in nature. And I don't understand how an interlock could work for somebody who had habitually driven and been charged with a DUI for heroin or another substance. And we do try to provide support and treatment programs for those who are addicted by other drugs, but it doesn't seem like we're doing the same for those who are addicted to alcohol. And so I'm asking, where does the department stand on those issues, and what happens specifically with interlock devices that wouldn't work because the person's on a substance other than alcohol?
That's a good question, Representative Spillane, and that's what I hear from people at some of these interlock hearings, that were not convicted of a DUI alcohol, they were convicted of a DUI drug, and that's what they will tell us. They say my issue didn't involve alcohol, so this interlock is not helpful for me for my case. I'm not sure if the interlock technology can ever advance to address the drug cases or not. If there's scientifically, I just don't know what the answer is to that, whether drug impairment can ever be detected in breath, or whether there's some type of an equivalent device that could detect drugs or not. So I think at this point that question is not able to be answered adequately, although I think treatment would be the answer for those individuals rather than an interlock device.
Follow-up, further question?
Follow-up?
Yep.
Thank you, Mr. Chair. I have a follow-up in that my question now is based on the extent of the epidemic of the opioid situation here in New Hampshire, and we are one of the hotspots in the country and have been. Have you seen data that shows that more of our DUIs percentage-wise are by those people not abusing alcohol but abusing other substances? And should we not start to focus on addressing the broader scheme of things?
Yes, that's a point well taken. I'm not aware of what the statistics are in terms of the breakdown between DUI alcohol or DUI drug convictions. And I'm not sure what the court statistics would be if someone's convicted of DUI impairment, if it splits out in the complaint, whether it's drugs or alcohol. In the body of the complaint it would, but I'm just not sure what statistics the court has on that distinction between drug conviction, DUI drugs as opposed to DUI alcohol.
Representative Bixby.
Yes, thank you, Mr. Chair, for taking my question. Thank you. I'm wondering how aware our drivers of what the penalties for DUI are at the moment, and whether would someone know that at the moment the potential jail time or prison time for a negligent homicide with the DUI was 6 to 12, and would they be aware that it got increased to 10 to 20?
Yeah, I'm not sure. I think it would depend on the individual, although I think there is a lot of public education about the dangers of drunk driving. And I think the general public knows that if you're driving drunk, you'll suffer a penalty, and you should suffer a severe penalty. But it's hard to say if they really know about the prison terms and the extended term of imprisonment as opposed to what's currently available under law.
Thank you.
I see other questions.
Mr. Chair, Representative True.
Oh, Representative True, I'm sorry.
Thank you, Mr. Chair, and thank you, Mr. Casco, for taking my question. It's good to hear your voice again. You testify in transportation a lot the last couple of years.
Thank you. Good to be here.
I know there's a division between the penalty DMV assesses, and I'm just trying to clear it in my mind one more time. DMV is like a civil case. You could lose your license from DMV, or you could lose your license at the same time being in a criminal court for negligent homicide or whatever due to DWI. There's two separate punishments going on, could be going on at the same time. Is that correct? It could be DMV losing license and criminal losing freedom.
Yes, that's correct. And in the negligent homicide case scenario, typically there would be a court suspension for someone convicted of negligent homicide, and usually that same case will go through an administrative hearing for a license suspension up to 7 years for involvement in a fatal motor vehicle crash. So those are separate, and someone who is suspended through our administrative process based on a fatal motor vehicle crash has to have a second hearing to be eligible to be restored. So they would serve the time. It could be up to 7 years, but it will be forever until they come back for another hearing. And we review certain criteria, make sure certain things were satisfied, even above and beyond what the court may require. If alcohol was involved, generally there needs to be a LADAC, licensed alcohol and drug abuse counselor evaluation as part of our license reinstatement procedure at the Department of Safety.
Thank you very much.
You're welcome.
I see there are no other committee members. So Representative Spillane, you have asked questions. You may ask another.
Thank you, Mr. Chair. I did have another question that just came up based on Representative True's question. Is the suspension of license done concurrently or consecutively to jail time? Because it doesn't seem to me that suspending a license while someone's serving their jail time is really very helpful. And I would hope that if they get a 7-year sentence in jail for manslaughter, that the 7-year license suspension takes place after they get out. And I'm just not aware of how that's done.
That's a good question. I think it's up to how the court imposes the sentence. It is a sentence I've seen that would commence the license suspension after release from incarceration. The same thing, I think we can word our hearing orders in the same fashion. And I know there was legislation, I remember a bill many years ago now, that I believe Representative Smith introduced to make that mandatory to have all the license suspensions commence after release from incarceration. My memory of that bill, though, is that it did not pass and was kind of left up to the sentencing court to address that issue at sentencing.
I see no other hands up. Thank you very much for your testimony.
Thank you. I appreciate your time.
I see Beth Shaw wants to speak again, the chair will allow it.
Thank you for the opportunity. I heard you all speak about a drug and alcohol program and whether that's addressed. And in our case, Mr. Leonard had successfully completed 2 drug and alcohol programs prior to killing my son. In his sentence, the judge did award 6 months off of his prison sentence if he successfully completed another drug and alcohol program, which we have since been notified that he has completed. And he has been awarded 6 months off of his sentence for completing that program for a 3rd time. And also, as far as license suspension, in our case, his license was suspended for 10 years. And during his 6-year prison sentence, those 6 years will count towards his 10-year license suspension, which is another failure of this process. If he's incarcerated and he cannot drive, that time should come after the fact of his prison sentence being completed. And that's another huge failure, whether it's the state, the courts, or DMV. But that I believe needs to be addressed.
Thank you very much.
Thank you.
No other hands? John, is there anyone else?
Mr. Chairman, I do not see anybody with their hands up or telephone.
Then we will close the hearing on House Bill.
Mr. Chair, if you could just ask Representative Hughes to count for the votes or support.
Representative Hughes.
Mr. Chair, we do have Catherine Cooper listed on the testimony list, and I do see her with her hand raised.
Yeah, I didn't see that before that.
It was not there.
Yeah.
Would you like me to allow that, Mr. Chairman?
Yeah, Ms. Cooper.
Thank you, Representative Welsh and members of the committee. This is Catherine Cooper here on behalf of the New Hampshire Association of Criminal Defense Lawyers. We oppose both of these bills for several reasons. And I would like to start by saying that I am so incredibly sorry for the loss of that young man, and I completely understand the frustration and just ongoing sadness that family is facing. Because there is no way to make these systems perfect. And I know that's no consolation, but it is unfortunately the reality. We do have issues with HB 179 because this does create a major escalation in the penalty for felony aggravated driving. And I would note that these are for first-time offenses. There's also, and I'm just being brief here, I did submit written testimony, and I would please ask you to refer to that because there's a great more amount of detail here, and I'm trying to be quick because I understand the time pressures. But the language in this bill is really confusing. It looks like there is a mandatory minimum trying to be created, but then it says the court can consider. So if both of these amendments are passed, the maximum penalty for the enhanced offense will actually be less than for the baseline offense. A 10 to 30 for neg ham or felony ag DUI with serious bodily injury would be 10 to 30. But if you have one prior DWI, it would be 10 to 20. So there are some significant drafting problems here for people who actually have to apply the statute and use it on a day-to-day basis. Also, with regard to, I'll move on to House Bill 347. The first, and this is for the operating after suspension charges. So the first part of this bill essentially elevates kind of a garden variety violation level operating after suspense or operating after suspension from a violation to a misdemeanor. And there were some questions earlier about people understanding penalties for the various driving offenses. And I can tell you in no uncertain terms that 99% of people who have sat in my office over the years and the offices of my colleagues have absolutely no clue the penalties that they are facing from the violations and crimes that they have committed while driving. It's a complex system, even when you work in it day in, day out, and the average citizen has really no clue. So there are huge problems with relying on things as deterrents in this area of the law. Also, there's a problem with this because it's actually an unnecessary elevation. And if what we're really after is trying to keep people who have convictions and priors in line and punish more severely, this already will happen, because if a person has an administrative suspension and a conviction for DUI, they're already subject to the 7-day mandatory minimum jail sentence for DWI suspensions. So, and also if the OAS is based on reckless op, they already are subject to a Class A misdemeanor for operating under suspension. Finally, just real quick, the second part of this bill extends the 7-day mandatory minimum jail sentence for operating after suspension to out-of-state DUI convictions. And I just want to point out that it might seem equitable to have a prior conviction from another state used as an enhancement for this, but you need to understand and be ready to devote a lot of money and a lot of time if you're going to make this a crime and look for it to be enforced. You have to get out-of-state records certified. The prosecutors and defense attorneys are going to have to spend a lot of time researching out-of-state laws and old case facts. And of course, this is going to result in the courts having to have more hearings and trials, because this is the kind of charge that people will fight when they're going to jail. Mandatory minimum for 7 days. This is one of those charges where judges don't even usually want to give people a 7-day jail sentence. So there's really no penalty for going to trial. You're never going to beat the offer. So we would request that both of these bills be voted inexpedient to legislate. Thank you.
That's good, but I have a question, and it's related to something that you said. How necessary is it for drivers to know the consequences if they're driving drunk? I think anybody would know you can't drive drunk. You shouldn't. Why is that statement?
I agree with you absolutely, Representative Welch, that people know when they're sober that they shouldn't drive drunk. Part of the inherent problem with drunk driving offenses is that the reason we don't want people driving drunk is because their judgment is impaired and they make stupid decisions. And one of them is getting behind the wheel. So it's a really tricky area of law when you're trying to control people's behavior, and the people you're trying to control are inherently being irrational and exercising poor judgment. So that's one of the really difficult parts of this. And it's, we have made a lot of progress in this country on discouraging drunk driving and trying to create a cultural shift with using designated drivers and making people think about their drinking before they have drinks and get behind the wheel. And I think in day-to-day life, a lot of progress has been made, but there's always going to be people that just don't respond to that kind of social messaging, and especially when they're people with severe alcohol problems.
Pratt. I have a question that goes basically to the same question Mr. Welch asked, Representative Welch. Don't you believe that after the first person is sentenced to a stiffer jail sentence for killing somebody in a motor vehicle accident, that the word would spread? You don't think that the public would realize after the first person was sentenced to jail for a longer sentence, that people would find out about that they would talk about it in the bars, would talk about it in their homes? You don't think the word would spread?
With all due respect, there's actually studies that show that does not happen, that the deterrence of individual cases does not spread. And in fact, it's kind of interesting. A lot of times My practice over the years was based primarily in the seacoast area of New Hampshire and in southern New Hampshire. And we would have people come in and complain about how weak the sentencing laws are. And when you actually question people further, it's because they were watching Massachusetts television. They didn't even recognize that the laws they were discussing were not the laws of our state, and were repeatedly shocked to find out that New Hampshire's laws were actually significantly harsher. So, it's when you do dedicated public education programs, I do believe that it makes a big difference, but I don't see a lot of impact from individual cases over the years, even when they are reported in the paper, and many times they are not.
Thank you.
Representative Spillane has a question.
Thank you, Mr. Chair, and thank you, Mrs. Cooper, for taking the question. Coming from a different perspective than the law enforcement one, which I sort of brought up the same question. How many of the problems that we're seeing with DUI these days are attributable to alcohol, and how many to other substances? And do you feel that a lot of the problems could be and should be addressed by confronting the underlying problem of addiction through mandatory treatment programs as part of the entire sentencing?
Thank you for your question, Representative Spillane. I 100% believe that our state should spend a lot more money on substance abuse treatment in general and for driving. I think there's a dearth of places for people to go and get help. We do have federal funding available, and in some parts of the state, they don't even have places to send the money to, because we don't have the structure set up to give people the help that they need on the ground. I think that's a huge problem.
I see no other hands up. Thank you very much for your testimony. Oh, hang on. Representative Newman.
Thank you, Mr. Chair, and thank you for taking my question. What is your opinion about including in the way the law is being amended aggravated DWI in with negligent homicide and murder by DWI, however that is? Do you think that mixture is appropriate or not?
I'm sorry, which section are you referring to?
Restate the question.
Yes, where it constantly refers to murder, negligent homicide, and I think that including aggravated DWI in with those two crimes, as I see it in the bill, that whether that's appropriate or not, based on the seriousness of the crimes and the seriousness of the penalties.
No, we would be opposed to that. And the reason being, those are first offenses, and by placing them there, it also sort of messes with the entire sentencing scheme by making sentences for crimes that are intentional versus negligent, or bad accidents, unintentional, have higher penalties than, for example, a first-degree assault or a kidnapping. I mean, this bill, what it does is it would make the penalty for first offense felony aggravated DUI, where the harm caused is unintentional, greater than for a first-degree assault or a kidnapping, where the person is actually intentionally harming someone. So I think that's a major problem.
Thank you for that. Thank you for that answer.
No further questions from the committee. Thank you very much for your testimony.
Thank you very much.
Now, Representative Muse, would you do the honors?
I will. For House Bill 179, there were 2 people who signed in support of the bill and 6 people who signed in opposition. And for House Bill 347, there were 8 people who signed in support and there were 2 people who signed in opposition.
With that, we will close the public, is that for both bills?
Yes. Yeah.
I'm sorry, I wasn't paying attention there. All right, we'll close the public hearing on House Bill 179 and House Bill 347 FM. We'll be in recess for about 5 minutes while we locate the chairman.
Be in recess longer than that, the next one doesn't.
Executive session.
That's right.
Outside the door, I think.
Everybody, are we on mute still? Can the representatives participating at home hear us? Thumbs up, thumbs down. Thank you. At this time, the executive session on House Bill, we now open the executive session, House Bill 347, developmental driving with suspended license. Chair recognizes Representative Rhodes to make a motion for Watts Pass.
Mr. Chairman, I'd like to make a motion to Watts Pass for House Bill 347.
Representative Walls?
I second that motion.
That motion has been seconded by Representative Wallace. Does anyone wish to speak on the motion?
Yeah.
Representative Boardman, if you are with us, I recommend turning your camera on. Representative Rhodes, you are recognized.
Yes, Chairman, I actually have a lot of things to say. I don't really know how to sum it up quickly. I just feel like if we have, I feel like personally there should probably be a zero tolerance when it comes to driving under the influence of drugs or alcohol. And
Representative Rhodes.
yeah,
I think we're on 347, not 1.
Yeah.
Oh, I'm sorry. I'm on the wrong one. Never mind. I was out of order. I apologize.
I feel first, as far Ms. Shaw, if she's still online, heartfelt condolences to her. And I think whenever she spoke, she was kind of speaking to both of these bills, and she just brought a lot of things to light. And I just think there should be zero tolerance policy, and I support Watts Pass totally.
Representative Gabriel.
First of all, enhance penalties. I typically struggle with because I really don't believe that it's a deterrent. Never has been for any situation. But even more importantly, I don't think were you in here when Captain Cooper was talking, because she talked about how confusing.
And Representative Jeff, I believe she was confused by House Bill 179. We're on, this is the executive session for
I'm
House
on
Bill
347.
347. I'm aware that this bill 347 passed in transportation last year, I believe, unanimously. And all it was believed to be a housekeeping matter, where it was the only driving offense that we could find where the an out-of-state offense was not taken into consideration. It did pass on transportation, I believe, unanimously, and then unfortunately was not taken into consideration in the Senate. I'm not sure if it was either tabled in the House because it's COVID-19 pandemic or it was tabled in the Senate, but
All right. Can I just say that one of the concerns that she had with the out-of-state for 347, okay, was the expense, not just for, let's say, the defendant, but also for the state in order to, and the length of a trial and all those types of things.
Well, I would say this, when I've represented someone who's charged with an offense, and then the out-of-state conviction is considered, the state has the burden of proving the prior offense. So it's the state's job or burden to really get the certified copy of the prior conviction. I know as a defense attorney, why would I won't request it, because I would just be requesting incriminating evidence against my client. I feel ethically that is a good idea. It's public record. I will leave it to the government to do their job. They're the ones that have to prove the case. If they fail to get that information for whatever reason, whether it's by their own discretion or they just fail to do it, what would happen is they're not going to be able to prove the prior offense, and that it would simply just be passed to be considered a first offense. If it's in state, it's much easier to get that information. So is an expense, request certified copies of the conviction from the court. I suppose it's the charges by state, but it's really not that, when I say expensive, it's not something that I would say is, overly expensive. I mean, it's just a certified copy to request.
No follow-up.
Yes.
Okay, and the other thing is that not only, let's say Massachusetts, their laws are different from New Hampshire. In most places, they're a little bit different. So that also meant, as she said, that you had to learn the law of that land. So I thought that was quite interesting. And my last question is, within the why 7 years preceding the date of the second? Verse 2 years, verse 10 years.
The 7 years is already the law. I don't know where that number came from.
Okay.
I didn't
That's
see
already
any
there.
problem with 7. This was just simply allowing you to take into consideration a out-of-state conviction for a similar offense. Again, it's the state government's burden to prove that it's a similar offense. If they can't prove that, again, they're gonna have to make that presentation. Otherwise, I mean, at a probable cause hearing, they're gonna have to, I would even say, provide some type of explanation for why it's a similar offense. Representative Pratt.
That same vein, like, commercial drivers, trailer truck drivers used to have a driver's license in every state. They used to have multiple offenses. They go from state to state and have offenses all over the country. And they said that they could never rein that in. Today, there's one commercial driver's license for your truck driver, and any ticket or any fine you get in any other state goes against that license. So I don't think it would be that much of a problem to prove if a person's in another state, they had 2 or 3 strikes against them, and then they moved to New Hampshire to get away from those 2 or 3 strikes. I don't think it'd be that hard to prove where they came from, that they already have 2 or 3 strikes against them on drunken driving charges or suspension or revocation. But I think it is something that can be done. It was said that they could never do it on drivers or truck trailer drivers, and they've created that problem all across the country. So I think it's something that could be easily.
Can you repeat what he said, because I can be able to hear him.
Representative Pratt, do you mind repeating what you said and just saying a little louder?
Yeah. So tractor trailer truck drivers, a number of years ago, maybe 30 years ago, used to have multiple driver's licenses across the country. And they would get tickets or fines or violations in the state that they were in. And then if they lost that license, it was okay. They had other licenses that they had in other states. And they said at that time that it'd be impossible in order to bring all these states together to try to figure out if a person has charges in another state. That has all been remedied now. There's one driver's license when you're a truck driver. Anything you do in another state goes against that license. And I don't think this is much different. I think if you're driving on a revocation or suspension, I don't think it'd be a problem that you could find that out in another state. And maybe somebody would move from a state that they've had 2 or 3 violations in to a state where they didn't have violations. It just isn't corrected. They could move here from another state where they have multiple violations and then start all over again, start the clock all over again. So I think this is something that can be done reasonably. You can find out from another state if they have multiple strikes against them. And I think it's worthwhile because you don't want to have somebody start on the clock all over again 3 times in another state or in other states multiple times. So I think it's something that's easily remedied. I think it's a good thing to fix.
Seeing no hands raised, the matter will now be put to question. If you were in favor of the motion to block the pass, please say yay. If you were opposed, please say nay. The clerk will now call the roll.
Vice Chairman Welch,
Aye.
Representative Burke,
Yes.
Representative Spillane,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harry Gathright,
No.
Representative Bixby,
No.
Representative O'Hearn,
No.
Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman.
Newman, please unmute yourself.
No.
Representative Golden.
No.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley.
Yes.
Chairman.
The chair votes yes.
Mr. Chairman, the vote for to pass is 14 yea, 7 nay.
By a vote of 14 yeas and 7 nays, the motion ought to pass is passed. Representative Rose, will you be preparing a majority report?
Yes.
Will there be a minority report?
I don't think so. Maybe somebody wants to write one.
If a member who voted in opposition wishes to prepare a minority report, please let me know by the end of the day today. At this time, we will now close the executive session on House Bill 347. At this time, we're opening the public hearing on House Bill 632, banning a sentence of life imprisonment without parole for a juvenile convicted of homicide. You know that the current sponsor is a conflict is currently in judiciary, so please, Representative Zafra, you can introduce the bill.
Unless is he on? Because
is Representative Birch available?
Who is it?
Representative Birch.
Mr. Chairman, I do not see him, so Shannon, Paul Birch, Representative.
And Representative Zafra, are you just for clarification, are you going to introduce the bill?
Yeah.
Defer testimony and questions? If you do that, the chair will allow exercise discretion and permit you to still question witnesses. If you testify and it changes that.
okay, I'm just introducing it because he's not here
Yes, okay.
later.
Understood. The chair now recognizes Representative Zafra to introduce House Bill 632.
Good morning. I am Representative Linda Harriet Gathright out of Nashua Hills 36, Ward 9, and I'm here to open up House Bill 632 for the prime sponsor. Just a little background on banning a sentence of life in prison without parole for juvenile convicted of homicide. Decades ago, in the tough on crime 80s and 90s, many states, stoked by fear of teen super predators, enacted laws to punish juvenile criminals like adults. The U.S. became an international, sentencing offenders under 18 to live out their lives in prison for homicide and sometimes rape, kidnapping, or armed robbery. There has since been a shift. Several years ago, the U.S. Supreme Court banned mandatory life without parole for juveniles in murder cases. Then last year, and I think this would have been 2019, the court went further, saying the more than 2,000 already serving such sentences must get an opportunity, chance to show their crime did not reflect irreparable corruption, and if not, have some hope for freedom. So we say that because in Massachusetts, for example, there's roughly 53 juveniles on life without parole. In 2015, Vermont eliminated life without parole for teens 17 and younger. New Hampshire, the statistics that I was able to get says that New Hampshire has 5 inmates life without parole for crimes committed at the age of 17. There were hearings scheduled for 2, and the other 2 have not been scheduled. And I believe that one was scheduled but refused to go to defend himself in that hearing. And Maine has no juvenile inmates. So more importantly, the United States is the only country that has life without parole for juveniles. And medically speaking, it's been documented over and over again that a juvenile, typically their reasoning and thought patterns do not mature until in the mid-20s. So that is what I have for now. I guess I could take questions if someone wanted to, but the Department does plan on being here later on.
And just is the intent of the chair to accommodate the Representative Birch's schedule? I know he's.
Yeah, and I do know that there are others that are testifying as well.
I'm just saying that in case I forget, someone can remind me. It happens.
Okay.
Representative Green?
Thank you, Mr. Chair. Thank you for taking my question. Do you know what the ages were on the ones that killed that woman in the Mount Vernon case?
I'm just gonna, is this recently?
About 5 years ago.
Well, then I would say that's one of these 17-year-olds.
Representative Green, I know the answer to that.
Well, Representative Swain, just let the witness answer the question. Thank you.
So,
Do you not know the answer?
well, like I said, the paperwork that I found said that all of them were 17 that were in prison here in New Hampshire. So if Representative Spleen has some more updated information, I don't have a problem.
Representative Spleen, you may want to address that.
Mr. Chair, one was 17 and the other was 19.
Thank you.
Thank you. Representative Welch?
Yeah.
Recognized for a question.
Representative, are you familiar with the Pamela Smart case and the 3 juveniles who committed the crime?
Mm-hmm. Yes.
You know where they are now? They're not in prison. She is.
Okay.
Just thought I'd bring that up because not all juveniles get life without parole. And those that do, it's a long time. I'm inclined to.
I believe that too. They get a long time. But what we're saying is that their lives matter as well. And again, they're in a, what I would say, more of not a mature state of mind. And I would like to believe that in this society, that someone that has been in prison for a while and is worthy of rehabilitation, and especially our young people. And there was, speaking of this, but I left it at home. I just happened to be online yesterday and there was an African-American male that had been in prison for murder. 86 years old, was released yesterday. And he had been there since he was a kid. So obviously somebody had decided what he was 86 years old. And I guess, well, at this point, he cannot do any damage in life. So let's just release him. But he was also one of those that were given life without parole.
Seeing no further hands raised, I want to thank the representative for introducing the bill and.
You good then?
Is Representative Tony Kaplan?
Kaplan. I'm not seeing that name, Mr. Chairman. They raise their hand if they're there.
If any members of the public wish to testify that have not testified already, please raise your hand. Is there a representative or not? Why should there, is there someone here to testify on behalf of the Office of the Child Advocates?
I see a hand raised. Yes, Mr. Chairman. Would you like me to?
Yes.
Yep.
And just for the record, just please identify yourself by stating your full name, where you're from, and whether you're testifying in support or opposition to House Bill 632.
Good morning. This is Moira O'Neill. Can you hear me?
Yes, we can hear you.
Great, thank you. For the record, my name is Moira O'Neill. I am the child advocate for the state of New Hampshire. I appreciate the opportunity, Mr. Chair, to speak in support of House Bill 632. The Office of the Child Advocate is an independent oversight agency. Recently, our jurisdiction expanded to children's services, all children's services that are provided or arranged by the state. However, our focus will always be children who are involved either in child protection or juvenile justice. So we support House Bill 632, sentencing a child to life without parole, even for a crime of homicide, runs contrary to what we know about the developing brain of children. The brain continues to grow and mature through early adulthood. Reasoning and critical thinking capacity evolves as the brain grows. And we know that children are more susceptible to influence given their developmental capacity. So we think about children as learning from mistakes or listening to what they're told, and that's sort of part of growing up. But actually it's a far more complex process than that. We now know from really elegant imaging studies and other research that the frontal lobe of the brain, including that prefrontal cortex, is still developing well into the mid-20s. And the structure and function of that part of the brain determines a young person's ability to think critically and to reason and to see even right from wrong. So the lack of development in that area of the brain is often cited to explain antisocial behavior. Children may not actually have the capacity to anticipate their consequences of their actions. So this extent of brain development in adolescence, meaning from the ages of 10 to 24, can be influenced by many factors that we're learning more about all the time, including environmental stress, risky behavior, drug use, sleep, sex hormones, nutrition, and other things, or psychological status. And that means as these influences build up in the developing brain, a child's brain at age 12 is very different than at 16, and then more different at 18. And so on. So most importantly, the part of the brain key to reasoning and insight and cause and effect is the last part of the brain to develop. So these significant differences in children's capacity, given their developing brains and the unique circumstances in which many of them come into the juvenile justice system, including trauma experiences, should really be considered in rendering sentencing decisions about their lives in the criminal justice system. Children who commit the crime of homicide are often severely abused and neglected and have experienced a tumultuous home life. Similarities have been found among children who commit murder, including having unreliable and ineffective caregivers, family members with criminal records, witnessing or experiencing violence, traumatic loss, and being rejected or abandoned by a parent. What the science tells us is the cause for children's behavior. It also predicts children's brains that will grow past that behavior if they're able to engage and be provided with supportive services. So it's not entirely hopeless that children will become better citizens. So over the past 20 years, and what we've learned in science about the developing brain has influenced a series of decisions by the United States Supreme Court regarding juvenile sentencing and proportional punishment. In 2005, the United States Supreme Court decided in Roper v. Simmons, in which it ruled that the 8th and the 14th Amendments of the Constitution ban imposition of the death penalty on offenders who were under 18 at the time the crime was committed. The court found that 3 differences between juveniles and adults demonstrating that juvenile offenders can't be reliable to be classified among the worst offenders. First, as any parent knows, and as the scientific sociological studies tend to confirm, a lack of maturity and an underdeveloped sense of responsibility are found in youth more often than in adults and are more understandable among the young. These qualities often result in impetuous and ill-considered actions and decisions. Second, as I mentioned earlier, juveniles are more vulnerable or susceptible to negative influences and outside pressures, including peer pressure. And third, the Supreme Court stated that the character of a juvenile is not as well formed as that of an adult. So personality traits of juveniles are more transitory and less fixed. That's all coming from the court. And then later in Graham versus Florida, decided in 2010, the Supreme Court ruled that the Eighth Amendment to the United States Constitution does not permit a sentence of life without parole for juveniles convicted of a crime other than homicide. In that case, the court found that life without parole is an especially harsh punishment for a juvenile. Under this sentence, a juvenile offender will on average serve more years and a great percentage of his time in prison than an adult offender. And it further noted that deterrence does not suffice to justify the sentence. And they cited Roper. The court stated that the same characteristics that render juveniles less capable than adults suggest that juveniles will be less susceptible to deterrence. Again, in another case in 2012, Miller versus Alabama, drawing from its decisions in Roper and Graham, the court decided that the Eighth Amendment forbids imposition of a mandatory life without parole sentence for juvenile offenders convicted of homicide. The court explained that children are constitutionally different from adults for purposes of sentencing. So it found that Graham's flat ban on life without parole for non-homicide crimes, noting that Graham said about children is crime specific. Those features are evident in the same way and to the same degree if a botched robbery turns into a killing. So Graham's reasoning implicates any life without parole sentence imposed on a juvenile, even as its categorical bar relates only to non-homicide offenses. So most fundamentally, Graham insists that youth matters in determining the appropriateness of a lifetime incarceration without the possibility of parole. In 2014, the New Hampshire Supreme Court ruled in petition of the state of New Hampshire that Miller decision applied retroactively to 4 New Hampshire respondents who had been convicted as juveniles of life without parole for homicide. And while the Miller court considered mandatory sentence of life without parole, its reasoning applies equally to any sentence of life without parole for juveniles. So banning life without parole sentences for juveniles who commit homicide will codify the principles espoused in those cases regarding sentencing of juveniles. It will also bring New Hampshire into alignment with other states. There are 24 states and the District of Columbia that have banned life sentences without the possibility of parole for juveniles. 4 states have no juvenile sentence to life without parole. None of to say that.
We do have to limit testimony. We have been limiting it to 2 to 3 minutes for hearing.
Okay, sure. So I'm happy to take questions if you have any.
We're at 7 minutes, so we do need to, I do need to ask you to suspend. It's the chair's mistake for not clarifying that before you begin your testimony.
Sure, understood. If you have questions, I'll answer them. Otherwise, thank you for taking my testimony.
Recognize for a question.
Thank you, Mr. Chairman, and thank you for taking my question. In your testimony, you spoke of the brain development from 10 to 24 years old. Now, in the 2010 Kimberly Gates case, one individual that was charged with first-degree murder was 17. The other one, first-degree murder, was 19. You know, this bill, if I understand it right, is just anybody under 18. So why not the 19-year-old if what you're saying is the, the 10 to 24-year-old, brain isn't mature enough?
Sure. Thank you very much for that question. And if we follow the science, then we would extend out the age limit. I think what you're considering is what is politically expedient. But certainly the scientists and the advocates for children would argue for an older age. And I will tell you from experience, because we meet with children at the Sununu Youth Services Center often, that I've actually had the opportunity to meet and know children who are moving on, not necessarily for life without parole, but for children who come into the system early, say around age 14, and then leave at 18 for an adult system. It's a completely different individual. There's a child at age 14 who has done something that was wrong and certainly acknowledges it. But at 18, it's a young adult who has completed schooling, is taking college courses, is helping out with other students, a completely different and responsible person whose life that he has to look forward to is behind prison bars.
Thank you.
Thank you.
I want to thank you for your testimony, and the chair would inquire, like to ask a question. I want to thank you in advance for taking my question. In your testimony, you stated that the development of the human brain is not complete until an average adult reaches the age of the mid-20s. If that is the case, why would this law? What's the rationale for having this simply be at the age of, the juvenile age? Wouldn't it be the age of the 20s?
Thank you for that question, Mr. Chair, and it's somewhat of a repeat of the other question in terms of the age limits. As I said, the science would support extending out a piece of legislation like this to older youth up to age 24. But as we all have to consider in public policy what's expedient for the community and what the community is comfortable with, I would stand by advocating for it to include older youth, but understand that that may not be expedient to pass.
Thank you for taking my question. Representative Klein Knight.
Thank you, Chairman, and thank you for taking my question. So if I'm understanding what you're saying is that the age that's written in this bill now is okay because we have to start somewhere. Is that correct?
Thank you for the question. Yes, it is. It would be a far better bill if it extended the age up to 24.
Thank you.
Seeing no hands raised, I want to thank the witness for the testimony.
Thank you very much for hearing me.
And just for the members of the public who wish to testify that are in attendance, please, at this time, please raise your hand. The chair will be limiting testimony to 2 minutes per witness. I do apologize that I did not state that before the prior witness began her testimony, so I apologize. The chair now recognizes Eric Alexander. Sure.
Yes, can you all hear me?
Yeah.
Thank you, Chairman, Vice Chair, and committee for having me with you today. I am Eric Alexander, and I serve as Senior Advocate for the Campaign for the Fair Sentencing of Youth, where we work to replace life without parole and other extreme penalties for children with age-appropriate responses to their actions. As mentioned earlier, the U.S. Supreme Court has made several rulings on this issue and has concluded that it should be reserved and applied only in cases where the individual is determined to be incorrigible. It went on to add that youth should be offered a reasonable opportunity for release. Since then, the majority of the country has moved away from life without parole as a sentencing option for children, and over 700 youth who were told that they would die in prison are now home. Over 140 of those youth, who are men and women, are active members of a network which I helped to co-found, which is ICANN. That's an acronym for the Incarcerated Children's Advocacy Network. All of them served time for homicide-related offenses and are now home living productive lives as, some as elementary school teachers, some as substance abuse counselors, paralegals, entrepreneurs, et cetera, contributing to their communities in a variety of positive ways with the understanding that, they could never repay what they took. They consciously decided to find their time in prison, finding ways to repay society for the mistakes that they made. These youth are not monsters. I can testify to that because I was once one of those children. At the age of 17, I was part of a crime that cost a man his life. And 2, I was on a case with a 19-year-old and also a 16-year-old. The only way that I avoided life without the possibility of parole was that I pled guilty to 2 25-year sentences. I served 10 years at that time, and I'm home now. I've been home now for 17 years since that time. I've been employed by organizations like the YMCA, the Metro Public School System here in Nashville, Tennessee. And now I'm, entering my 4th year in my tenure with the Campaign for the Fair Sentencing of Youth. So I said all of that to say that these are the type of things that these youth are capable of when they come home at a reasonable time. Again, I went to prison at the age of 17 and I came home at 28. Since then, I'm a married man. I have 2 beautiful daughters, the age of 5 and 3. So I've been able to put my life back together in a very meaningful way. And I truly believe that this is what the Supreme Court said when they meant that these children should have a meaningful opportunity for release. Now, as someone who spent time in prison, I'll tell you that not all youth will meet the parole board standard, but they should have an opportunity to sit in front of the parole board and have the parole board to have an opinion on if they are a citizen that's available for release, or if they are someone who needs to spend more time in prison getting their lives together. Thank you for having me with you today.
I want to thank you for your testimony. Seeing no hands raised, the witness is excused. At this time, the chair will now recognize Representative Paul Birch. I did state that testimony will be limited to 2 minutes per witness. However, Representative Birch is the prime sponsor and was unavailable at the start of the hearing, so there will be some flexibility with that. With respect to the representative.
Thank you, Mr. Chair. I appreciate the courtesies I've received from you and the committee. I was tied up in judiciary doing execs until a few moments ago. I am the prime sponsor of HB 632. My name is Paul Birch. I represent Cheshire 1, which are the towns of Westmoreland, Walpole, Chesterfield, and Hinsdale, along the banks of the beautiful Connecticut River. I assume by now you have heard from various experts and other folks who have an interest in this bill. I wasn't able to hear them because I was tied up, but I will keep my remarks quite short so as not to repeat what they likely said. I filed this bill in part because actually I got a pretty thoughtful letter from an inmate at the Concord State Prison who would not be subject to this bill, but felt that this would be an important bill judging from what he has learned and what he has seen. As a former public defender and as a legislator, I get a lot of such mail. This one kind of struck me in a certain way, so I decided to file the bill. As has been noted, this bill does not guarantee the release of any offender, just a review after a reasonable period of incarceration with an individualized assessment, of course, of the unique circumstances of each offender. And I want to make a point, I don't know if it was made earlier, but it also allows the victim's family and friends to possibly evolve their own thinking about what a just and a compassionate sentence might be. At a point in time, maybe a year after the loss of a loved one from a violent crime, they may have one point of view, and 30 years later, they may or may not have a different point of view. And I think it's respectful of those folks to say, yes, we want to hear your changed point of view if you have it, or your non-changed point of view, and take that into account in figuring out a continued sentence or not. As you have heard, most states have either eliminated this statute in law or in practice. And this is based on what we know of child development. Our knowledge of child development has changed a lot over the last few decades. And that's been reflected in court decisions, which I'm sure have been mentioned to you in the earlier testimony. You know, immaturity of children, susceptibility to outside pressures and influences, inability to assess consequences, all suggest that punishment for adults should be considered different than punishment for children. There's a cost factor, of course. It's expensive to jail folks. The national average is about $35,000 a year. It goes up tremendously for geriatric prisoners. It's an issue that's larger than this bill, but it's an issue that affects all of us who work in our county budget committees and on our state budgets. But the costs of care for geriatric prisoners is double that of younger prisoners. So it's an issue as taxpayers would like us to look at. There's an issue of rehabilitation and rehabilitative programs. If you have a child who's locked up for life, there's little incentive to give him or her any kind of meaningful rehabilitation under the theory that they're not going to ever be released. That's not good penology. It's not good. It's not good corrections to have that approach, but it's there. I hate to say it, but there's racial disparities in a lot of the criminal justice issues, and this one is no exception. The imposition of life in prison without parole for children has been found to be racially disparate, similar in capital punishment and other kinds of similar issues. So briefly, that's where I'm at in filing this bill. It's a nonpartisan bill. It's not left or right. It's a good government bill. And basically sentences that sentence juveniles to jail for the rest of their lives without the best possibility of parole, close the door on rehabilitation and second chances, deny the family and friends of the victim the chance to revisit and rethink their position about what an appropriate sentence is. And it's basically cruel and misguided. So I hope you will support passing HB 632. Thank you.
Representative Burst, I want to first thank you for your testimony. The chair may inquire of a few questions. Are you familiar with the prior witness referenced the Miller versus Alabama case? And I believe that my understanding of the holding in that case, and please just correct me if I'm wrong, for a juvenile, the Supreme Court ruled that there can't be a mandatory sentence of life without parole for a juvenile. However, a juvenile could still be sentenced to life without parole, but it's just the law can't mandate that. Is that, would you agree that that is the holding in the Miller versus Alabama case?
That is correct.
And then thank you for taking my question. And my follow-up question is, in the state of New Hampshire, with the exception of first-degree murder, are there any other offenses that you are aware of where the mandatory sentence would be for a juvenile, where they would be sentenced, that juvenile would be sentenced with life without parole?
No, I'm not aware of any.
Thank you. So this would really just apply to first-degree murder, is what we're aware of?
I believe so. I mean, I have to check on what the penalty on second-degree murder is, because I think maybe in New Hampshire, it's the same penalty for first and second, but I'm not positive of that.
I think that, and someone, I'll just give everyone a heads up. I was looking at that right before I asked the question. The RSA 630 would apply. I believe first degree murder, it's a mandatory life without parole, but second degree, you can be sentenced to have a life sentence, but it's not necessarily the automatic denial. I'm only aware of first degree murder. I'm just wondering if there's any other offenses.
Right, but under under the Miller case, the mandatory life without parole for juveniles is not allowed anymore.
Yes, so I guess the feeling is that so based on the testimony and your understanding of the Miller versus Alabama case, RSA 630:1, if a juvenile was convicted of first degree murder, that sentence as applied in that particular circumstance would violate that Supreme Court holding.
If they were given given as a mandatory, yes, I agree.
Thank you, Representative Birch. None of those questions, I appreciate you taking them. Representative Muse.
Yes, thank you for taking my question. Just wanted a little clarification on the bill, that the way that it's actually written. Is it possible under your bill for a juvenile to still receive a life sentence for a crime, but with the stipulation that that they would be eligible for parole at some point?
Under this bill, a juvenile could still be sentenced to life imprisonment. There's no guarantee of any parole. All this does is say that at some point in time, the juvenile is entitled to a hearing before a parole board, which can say yes or can say no. In other words, if the parole board thinks each time or whenever they see this person that this person should remain in jail, and that's the decision that is made for the rest of that person's natural life, that's what will happen.
Thank you. That was my assumption, but I didn't want to assume. Thank you again.
Representative Burns, if the chair may inquire a follow-up question. So this is just my reading of what would, if this were to pass and be signed into law, it would be a new section, RSA 630.17 would appeal. I'm reading that to say that no juvenile convicted as an adult for an offense can be sentenced to life in prison. So although that would satisfy the Miller versus Alabama holding, I'm reading this to not allow any circumstance where a juvenile is sentenced to life without parole. Because my understanding is like on the second degree murder, it's some discretionary factors may be considered by the judge to actually, issue a life sentence, but it's just not a mandatory sentence. I guess my question is, I'm reading that differently. I believe you should testify that, unless I misunderstood.
I'm not sure I follow. I try to make it as clear as me and OLS can make it that, I mean, the Supreme Court has ruled out for this category of offender, life in prison with, mandatory life in prison without parole. That's off the table. This takes it, that sentence of life in prison without parole for a juvenile convicted of this offense off the table. It means that it has to be some ability to face a parole board. It does not guarantee parole. It just says you have a right to ask for parole or have a parole hearing in due course.
Thank you for taking my question. Seeing no news raised, Representative Allen, in your testimony. Chair now recognizes Preston Schiff. And this public who is on testifying, please, that are in attendance, please raise your hand at this time. Preston Schiff, you may begin your testimony, and please try to limit testimony to under 2 minutes.
Thank you, Mr. Chairman, and thank you to the other members of the committee and to Representative Birch for introducing this legislation. I'm Preston Schiff. I serve as senior counsel, senior policy counsel for the Campaign for the Fair Sentencing of Youth. You've already heard from my esteemed colleague, Eric Alexander, and so I will not duplicate his testimony. The thing that I would like to share with you, because you're getting it right, you've heard about the U.S. Supreme Court cases. The campaign has been working on this issue since 2009. And so we have been active in states all over the country. You've heard that 25 states so far, including DC, 25 have already passed this kind of legislation. So the only thing that I really wanted to add was just to let you know that if you pass House Bill 632, you're basically bringing yourself in line, not just with your neighbor of Vermont and Massachusetts, but also West Virginia and Ohio, Utah and Wyoming and Nevada, and believe it or not, Arkansas and Texas. Texas was one of the first states to abolish life without the possibility of parole for kids after the Miller decision in 2012. The very next year, Texas passed a law saying that no child could be sentenced to life without parole in their state. They basically said that, if a kid is too young to vote, too young to sign a contract, too young to serve on a jury or in the military, then that person is too young to be condemned to die in prison. And so New Hampshire would certainly be in good company, both conservative and progressive states. The bill we just saw passed in Ohio, Republicans have super majorities in both chambers in Ohio. And they took this issue up and really showed that this this is a conservative issue, not just a progressive issue. And so we're really, really happy for this opportunity that New Hampshire has. Certainly, we want to be a resource for you. If there's any questions or materials that we can provide, we would just love to do that. And again, we thank you for your consideration today.
Thank you for your testimony. Seeing no hands raised, I want to thank you for your testimony, and you are excused. Is Representative Tony Kaplan?
I am not seeing that name, Mr. Chairman.
Chair now recognizes Ms. Hareska. If any members of the public who are present and wish to testify, at this time, please raise your hand.
Thank you, Mr. Chairman and members of the committee. My name is Jeannie Hareska. I'm the political director for the ACLU of New Hampshire, and I appreciate the opportunity to appear before you again today in support of HB 632 and ending the inhumane practice of sentencing children to life in prison without the possibility of parole. I want to respond to some of the questions that have been asked about whether to extend this to 19-year-olds, and I appreciate the question. And what I want to know is, as a society, we have put significance on the age of 18. This bill does not come up with that distinction between 18 and afterwards. Minors are not considered responsible enough to live away from their parents, to make decisions related to their education or medical treatment, to vote, to sign a contract. And yet they can be certified as a so-called adult and sentenced to spend the rest of their lives behind bars. What an LWOP sentence means is that someone is irredeemable. I don't know how we say that about a minor who is still developing, including cognitively. You're saying that a minor, somebody as young as 13, 14, 15 is irredeemable, even if given decades to rehabilitate. I just don't know how we say that. And I think it's really worth noting that the United States is the only country in the world that sentences people under the age of 18 to life sentences without the possibility of parole. And as previous witnesses have noted, the trend within the United States is to do away with these sentences. 24 states plus DC have already done so. So it's a great opportunity here for New Hampshire to catch up. And I just want to note again, this bill does not prevent young people from being held accountable. That is not the question. If you commit a heinous crime, you should be held accountable. This bill simply ensures that a minor is not condemned for life for something they did when the world over recognizes them as immature and not fully cognitively developed. Juveniles who commit heinous crimes would still face accountability, they would still face stiff sentences, and would still go before the parole board and have to prove that they have been rehabilitated and worthy of parole. So, and I do want to know, as there have been a couple individual cases referenced in New Hampshire, and there are currently a couple cases pending. Like, this is a very relevant issue here and now. This is a value question. This is a value of how our state treats children. So I strongly encourage this committee to really consider HB 632. I will know, I understand there's some confusion about the wording, given the LWOP terminology. So maybe the wording could be clarified so that the questions that the committee raised about the specific phrasing of the bill don't continue, and it's very clear what the bill is striving to do. But I very, very much support the intent of the bill and urge this committee to pass this legislation. Thank you very much.
Thank you for your testimony. Representative Burke, you're recognized for a question.
Thank you, Mr. Chairman, and thank you for taking my question. And I guess maybe I should have asked a previous speaker, but maybe you know the answer. How many are currently serving a life sentence that were sentenced under 18 in New Hampshire, and how many in the past have been sentenced that, and they may not be with us today?
I don't know that off the top of my head. I think the number 17 was mentioned earlier today, but that's just me quoting a previous witness. I don't know that off the top of my head.
All right, thank you.
Seeing no hands raised, I want to thank the witness for her testimony.
Thank you.
The chair now recognizes Helen Hanks.
Oh, you may know.
She sent us something.
Good afternoon, honorable members of the committee. My name is Helen Hanks. I'm the Commissioner of the New Hampshire Department of Corrections. I've just been an active listener to your testimony today in response to Representative Burt and to Representative Harriet Garthwaite. I just sent you a data set to help you answer those questions. And certainly we stay neutral as you vet this question, but avail ourselves to provide you any information that assists you in vetting this proposed piece of legislation. So I just want to point you to your emails. There's some information there. In addition to, I did send you the healthcare cost by age group. I did see a typo in my state fiscal year 2020. I just want to assure you it is state fiscal year 2020. You'll see a reference to 2018. And we're, again, here to help triage any information you might need. Thank you.
Thank you, Ms. Hanks, for your testimony. Representative Burt, you're recognized for a question.
Thank you, Mr. Chairman, and thank you for jumping in here and sending us that information that I'll definitely look at. But I don't know if in the information it states what my question was, is that, you know, how many are currently serving life sentence that were sentenced under 18 years of age currently in New Hampshire? And then let's say back, you know, the 200 years, 250 years we've been here, how many have done that?
Representative Burt, it's actually a pretty detailed data set you'll find. It gives you the age they were at the date of offense. It gives you the crime. It gives you the date of their crime. You'll see a reference to minimum and maximum. The numbers 99 denote a life sentence. Did also give you additional data for people who are serving 50 years or more. That's pretty significant. And it has, you're going to see a lot of detail. There are public data sets. So we just wanted to get that to you. I could not commit to some long-term data as we switched systems back in 2008, but I'll try to see what I can find for historical perspective with regard to the state of New Hampshire.
Thank you.
You're very welcome.
Seeing no hands raised, I want to thank the witness for her testimony, and the witness is excused. If there's any members of the public in attendance that wish to testify that have not testified already, this time please raise your hand. Seeing no hands raised at this time, we will close the public hearing on House Bill 632. Representative Muse, do you want to do the honors?
Yes, people signing in on House Bill 632. There were 152 people who signed in support. There were 5 people who signed in opposition.
Thank you, Representative Muse. And we're going to go into a recess very shortly, but just something for everyone to think about. What I've at least been reviewing during the hearing and what we heard from testimony, the Miller versus Alabama case, pretty clear. You can't have a mandatory life sentence without the eligibility of parole for a juvenile. In New Hampshire, the first degree murder law, RSA, it's RSA 630:1-A states that that offense is a mandatory of life without parole. So that, as written, applied to a juvenile, would not pass the Supreme Court muster. That's the holding of Miller versus Alabama. But something to think about is whether we would want to forbid a life sentence without the possibility of, a judge can still make or issue a life sentence. It's just a matter of it being mandatory. Miller doesn't prevent a judge from doing that as part of the sentence. It's confusing, but just something to think about. Do we want to make it so it's impossible to, under any circumstance, for a juvenile to serve a life sentence without parole? But I think we each need to consider whether we have to eliminate the mandate of that, because the law is pretty clear on it. So there's something to consider about. We'll be doing some executive sessions. Let's plan to be back at 1 p.m. and we will be in recess.
Fine.
Who got that time? Not me.
Just for the members in the room, if your speakers are also unmuted, that would also cause an echo like that.
The learning curve.
I think it's gonna be exactly until 1:45. Yes.
Just like your hat.
And there was a water jug I had somewhere. No, there's water.
Yeah.
Wherever.
And a notebook.
All right. Good afternoon, everyone. Can the members at home hear us? If they can, could we have a thumbs up from Representative Bradley? We are going to be opening a few executive sessions, so recommended you can turn the cameras on. Representative Bolton.
Doesn't look like she's with us.
Recommending someone reach out to her, and preferably via text message. At this time, looking for a copy of the actual bill.
Oh.
I have it somewhere.
Okay. Right.
Good afternoon, everyone. At this time, we will open the executive session on House Bill 179 relative to enhanced penalties based on prior convictions for driving under the influence of drugs or liquor. At this time, the chair will recognize Representative Rhodes to make a motion about the pass, and I believe offer an amendment.
Thank you, Mr. Chairman. I do have an amendment for House Bill 179, submitting ought to pass the amendment. The amendment is 0210741H.
And is there a second to that motion about the pass? That's been seconded by Representative Green.
I second the motion.
Thank you. And you wish to offer an amendment?
Yes, amendment 2021-0741H.
I never get the number.
You wish to speak on that amendment?
Second.
Which one was that on? One?
179. I don't have it. Passed around this morning. Didn't pass by me.
0714.
That,
For one.
I think it actually was over there as well.
David, could you grab me one, please?
Does everyone have a copy of the amendment?
I know I have it.
That's the one that named it Tyler Shaw's Law, right?
Yes, and that, to my understanding, the only correction, or only part of the bill that's being amended would be to add that title at the beginning. So it doesn't change the substance of the underlying.
You took mine, 'cause I did want it.
You have to see the copy of it?
I have it on.
Oh, okay.
Yeah.
There, anyone wish to discuss the amendment? Seeing. Seeing no hands raised, the matter will now be put to question on whether, the question is whether to adopt, amendment 2021-0741H. If you're in favor of adopting the amendment, please say yay. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Welch,
Aye.
Representative Spillane.
Aye. Out of order.
Oh my gosh, I wrote Bert, I'm sorry. Okay, Representative Burt,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testament,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yay.
clerk votes yes. Representative Harriet Gathright,
Yes.
Representative Bixby,
Yes.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
No.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman?
The chair votes yes. And for the
Yes.
record, could you call Representative Spillane?
I did call his name first and then went back to Representative Burt. Mr. Chair, the vote is 20 yay, 1 nay.
By a vote of 20 yeas and 1 nay, the amendment is adopted.
What was that?
Representative Rhodes, you now wish to make a motion about the pass as amended?
Yes, thank you, Mr. Chair. I'd like to make a motion for House Bill 179 ought to pass
As amended?
as amended.
Is that seconded? It is seconded by Representative Wallace. You wish to speak to the motion?
Yes, I first like to say I apologize. I had my notes written on this particular bill and I was stuck on the other bill prior, both having to do with driving under the influence. So I apologize for that confusion, but we had a lot of testimony today. One of the things that is really ringing a bell to me is there was testimony that, well, when a person is driving under the influence, they're not able to make the best decisions and therefore they shouldn't be held responsible, which is a little bit hard for me to understand. And also listen to Ms. Shaw's testimony, as I was saying before, and her, really bringing to light, just using the exact words what they are, is the son was killed. And it wasn't by a person that was making a mistake. It's a person who made a clear conscious decision to drive while they were drunk repeatedly. And schools have a zero tolerance for bullying, but yet we don't have a zero tolerance for things like this, where, her words could be more harmful than someone driving drunk is really hard to understand. So with that being said, I think we ought to pass it.
We're now open the question for discussion. Representative Muse, you're recognized.
Yes, one of the things we've heard, over the course of, of this year in criminal justice is that sometimes the worst case scenario cases don't necessarily translate into the best state law. I have no doubt that that what happened to Ms. Shaw and her family is terrible. But I do have doubts as to whether or not this bill is actually going to move us any farther towards fixing this problem. I think one of the things that we heard in the testimony were a lot of people who were extremely well-intentioned, who were also trying to explain to us some other holes that that we needed to fix. There are things regarding the instrumentation that takes or that offenders have to breathe into in order to start their cars. We're looking at an extremely significant increase in the penalty for this, and I think one of the things that Ms. Cooper pointed out to us is that we would actually be making a crime that I'm not sure anyone would intentionally ever commit into an offense with a greater punishment than a lot of offenses on our books that people commit with full intent. So I'm regretfully, I have to say that as the bill currently stands, I have to vote against it.
Seeing no further hands raised. Representative Newman, you're recognized.
Thank you, Mr. Chair. And I agree with Representative Muse, and my primary objection to the bill is that there are many ways that you can commit aggravated DWI, and the inclusion of aggravated DWI into the laws that cover manslaughter and murder DWI, I think is just not appropriate. So I'm going to vote against this bill. Thank you.
Representative Green.
Thank you, Mr. Chair. Being in criminal justice and public safety for 4 terms and seeing a lot of bills come through where they're trying to protect the guilty and not the victim. And I just feel bad that the victims aren't looked at so much in this state, or maybe not this state, but just across the country. And I will be voting yes on this.
Representative Welch, you're recognized.
I'll go. Back several terms ago, we had another DWI bill which had a mandatory jail sentence for the first time offender. And the reason I got involved in that one was because my niece, who lives in Washington State, was driving with her fiance on the car, and they got hit head on by a guy. And he said, this is the first time I've ever driven drunk. Well, statistics show that people who get caught DWI have probably driven 2,000 times without getting caught. I'm going to vote for this. By the way, her fiance is no longer with us. And she went through the windshield.
Seeing no further hands raised, the matter will now be put to question. If you support of the motion ought to pass as amended, please say yay. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Welch,
Yes, indeed.
Representative Burt,
Yes.
Representative Spillane,
Yes.
Representative Green,
Very much yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yay.
clerk votes yes. Representative Harry Gathright,
No.
Representative Bixby,
No.
Representative O'Hearn,
No.
Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Bolden,
No.
No.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
The chair votes yes.
Mr. Chair, the vote is 14 yay, 7 nay.
By a vote of 14 yeas and 7 nays, the motion of ought to pass as amended has passed. I do know that Senator Feltus couldn't make it today, but I will give him credit for drafting the original version, which was Senate Bill 743 last year. This time we will now, Representative Rose, will be preparing the majority report.
Yes.
Will there be a minority report?
Yes.
At this time, we will now close the executive session on House Bill 179. At this time, we are opening executive session on House Bill 196. I do not have a copy of the bill. If someone wants to read the title, that would be greatly appreciated.
Mr. Chairman, it's an act adding trespass as an exception to the charges of criminal threat. Oh, exemption, I'm sorry, exemption. Let me reread it with my eyes.
That's from last week.
Yes, and there was an amendment, I understand, Representative Burke. Do the members at home have a copy of the amendment? At this time, the chair will recognize Representative Burke. Make a motion.
Thank you, Mr. Chairman. I'd like to make a motion ought to pass with an amendment.
Yes, and can you please read the, is that, when you say ought to pass with an amendment, are you referring to, you make a motion of ought to pass, you're gonna offer an amendment, is that amendment number 2021-0758H?
Yes, it is, Mr. Chairman.
Thank you. And who is that seconded by? Seconded by Representative Rhodes. Representative Burke, you wish to speak to the amendment?
Yes, Mr. Chairman. What the amendment does, it basically removes the $1,500 amount out of the current bill that is being proposed. And the reason I thought to do that was to, it's hard to determine what values are on some items. And when it comes to certain items, the value may be less, but to the person, it's everything. So by allowing not to have any amount, I think just makes the bill more enhanced and better. Thank you, Mr. Chairman.
Thank you, Representative Burt. Now open the question up for discussion. Seeing no hands raised, the matter will now be put to question. If you are in support of adopting Amendment 2021-0758H, please say yay. If you're opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burt,
Yes.
Representative Spillane,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harriet Gaffray,
No.
Representative Bixby,
No.
Representative O'Hearn,
No.
Representative Bordenay,
Yes.
Representative Muse,
No.
Representative Newman,
No.
Representative Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman.
The chair votes yes.
Mr. Chair, the vote is 12 yea, 9 nay.
By a vote of 12 yeas and 9 nays, Amendment 2021-0758H is adopted. Representative Burt, you know, we should make a motion of ought to pass as amended.
Yes, Mr. Chairman, I would like to make a motion to pass as amended on House Bill 196.
Representative Rose, you wish to second that motion?
Yes, Mr. Chairman.
Representative Burt, do you wish to speak to the motion about to pass as amended?
Yes, Mr. Chairman, thank you. And very briefly, this bill just allows people to be able to defend their property without being criminally charged, and certainly on this incident of defensive displaying. And hopefully we'll all vote for it. Thank you, Mr. Chairman.
The matter will now be open for discussion. Representative Conley.
Thank you, Mr. Chairman. This committee dealt with bills of this kind a lot this session. RSA 627-4, physical force in defense of a person, essentially our self-defense statute is very clear. It is also already addresses this situation and basically any other where somebody has a reasonable concern about their own safety or about their property. This bill and others like this term have created what I see as carve-outs to a statute that already intends to address situations much like this one without specifying where it would occur. I don't think this bill is needed. RSA 627-4 clearly addresses this exact same scenario considered in the bill. The bill makes it less clear. The current statute perfectly addresses this. We don't need this bill.
Representative Muse.
One of my biggest concerns with this bill and some others that we've had in this session that are similar is that to a large extent, these bills are motivated by fears of protests in other states that simply haven't happened in New Hampshire. I have a problem.
Muse.
Sorry?
Muse, yeah, because we are, as a, the decorum, we are not allowed to speak to other members' motivations for filing the bill. So I just ask that you refrain from that. However, you may continue. Thank you.
Thank you. I have a general problem with people trying to settle arguments or disputes with a gun. That's what words are for. And another thing that I worry about in a state that has a first in the nation primary and then one where where politics seems to be our state sport instead of football, basketball, baseball, or hockey, is I worry about the impact on canvassers. I've actually experienced an incident myself where I was going up to knock doors back in the 2016 election, and I was looking to talk with the woman of the house, and the man of the house was outside raking leaves and asked me who I was canvassing for. And when I told him, he pointed at a pistol at his side. So, you know, these are the sort of things that we open the door to with this bill. And I think it's one of the reasons why we really, really need to think twice before we pass it. Thank you.
Representative Gabbard.
I just want to remind us that when, in the sign-up sheet, there was 12 to support and 53 in opposition to this bill. And I think that sometimes we really need to take a look at that as to why people are opposing bills or why they're actually supporting a bill. I just thought I would share the information.
Representative Wallace.
Thank you, Mr. Chairman. Thanks for letting me speak. This bill would provide legal protection to a property owner who is taking a defensive posture with a firearm or another means of self-defense to neutralize or de-escalate the threat in a criminal threatening situation. This doesn't have anything to do with canvassing or being at the mall or anything like that. It's specifically to help you de-escalate a situation on your own property or curtilage. It's as simple as that.
Representative True.
Thank you, Mr. Chair. I do support this bill with the amendment. I believe it is very possible for somebody who is to be found innocent of such an action to be financially ruined just by defending himself in court. This restates and clarifies the situation where a person is certainly within his legal rights to protect himself in his property. Thank you, Mr. Chair.
Just to expand on that, by expanding on when a person can defend themselves and specifically display a firearm in a defensive manner, it also specifies and implies when it's not appropriate. I believe the example provided by Representative News, just based on what he said to us, that would sound very inappropriate display of a firearm. Because it doesn't sound, and knowing Representative News very well, it doesn't sound to me like there was any reason to believe, nor would a reasonable person believe that Representative News would ever cause property damage, seriously bodily injury, or death to anyone. So that I would say that this clarifies when it's appropriate. And unfortunately, sometimes when laws are more broad, it makes it very difficult to prosecute. This really narrows when it is appropriate. So this could be interpreted really as a narrowing of when it's appropriate by describing it that way. So, Representative Muse. You're on mute, by the way. Representative Muse, you're the packet system.
Something that I think we need to consider is the fact that, yes, people can interpret the law differently, but I think that there's a real risk of this particular statute being misinterpreted into just a broad allowance of exactly the kind of behavior that I described. Most citizens don't write the laws. Most citizens never read our laws. What they do is they hear about our laws. I think I have a legitimate concern that there are going to be people who misinterpret this legislation and who think they have the ability to do something that I don't think the people who drafted this law intend for them to do. So I think that there's a real danger here of unintended consequences, and I really think that sometimes we do need to pay attention to these things as legislators.
Seeing no further hands raised, the matter will now be put to question. If you are in support of the motion about to pass as amended, please say yay. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Welch,
Aye.
Representative Burt,
Yes.
Representative Spillane,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harriet Gaffray,
Nay.
Representative Bixby,
No.
Representative O'Hearn,
No.
Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman.
The chair votes yes.
Mr. Chairman's vote is 11 yay, 10 nay.
By a vote of 11 yeas and 10 nays, the motion of ought to pass as amended and passed. Will it be majority report, Representative Burt?
Yes, there will be. Tonight before 10 o'clock.
Representative Conley, you'll be preparing a minority report? Thank you very much. At this time, we will now close the executive session on House Bill 196. At this time, we're opening the public hearing on House Bill 557 relative to the authority of the state and county correctional facilities to discipline inmates using codes or solitary confinement. Chair now recognizes Representative Holden to offer, introduce the bill.
Thank you, Mr. Chairman. I hope you can hear me okay.
You can hear it.
Thank you, Mr. Chairman and members of the committee for taking my testimony today. My name is Amanda Bolden and I represent Hillsborough District 12, which is Manchester Ward 5. In introducing House Bill 557, I just wanted to clarify some terminology. Close confinement, solitary confinement are all the same. Generally, they represent the same ideas. In our state facilities, they refer to it as C5 status, but I anticipate that the commissioner of the Department of Corrections might testify today as to the difference between C5 status and what you might think solitary is based on television shows, things like that. So the intent of this bill is to repeal antiquated laws and to preserve the currently accepted use of solitary confinement in our facilities. Basically bring an update to the law and put it in line with the current practice in our facilities. The original law that created the county prison system in the 1800s, at the time it was only a county facility. We didn't have a state facility, and it was in the 1800s that the RSAs forked, and we sort of set up a separate county system and a state system that were run by different bodies and had eventually a very different set of laws dictating what goes on in those facilities. So over time they were recodified, and in the last century and a half, the original terminology has been slowly peeled away by subsequent legislatures. And right now, very little remains of what was originally the laws for the county facilities in the 1800s. So for example, the section of law that Section 2 of this bill repeals originally said, in part, if any prisoners are refractory and stubborn and refuse to work or to perform their work in a proper manner, then the superintendent may put them in close confinement until they submit to perform their task and obey his order. and in the case of great obstinacy and perverseness, may reduce them to bread and water till they submit and obey. So in the 1800s, concepts of criminal justice and reform were a little different. And you can see that over time, at a minimum, if you've looked at the RSA that Section 2 repeals, then you would observe that at a minimum, the portion about only feeding prisoners bread and water has been repealed since then. And another now repealed section, it's completely gone from the law, says that if any prisoner shall abscond, escape, or depart a house of correction without license, that they can be restrained using fetters or shackles. So a lot like the law against adultery that was repealed by this body maybe 4 bienniums ago. New Hampshire has a lot of really outdated laws on the books. The terminology is certainly outdated, but so are the policies. As members of the Criminal Justice Committee, you've probably heard before that the Quakers are believed to have originated the concept of solitary confinement in the 1800s, and I think in the 1700s as well. The Quakers hoped that by giving someone solitude and a Bible and maybe a skylight, they could look to God, look upward to God, and consider their sinfulness and consider how they might become better people. And this method became popular because it was considered, it became popular outside of Quaker groups in the nation in general, because it was considered to be more humane than public floggings or hangings at the time. But eventually the Quakers abandoned the practice when they noticed that the people that they were trying to reform so that they could be productive members of the community were coming out of their solitary confinement violent and very different. And they, without access to science and concepts like that, they regardless began to question whether their program was effective. And keep in mind, when solitary confinement became popular as a humane alternative to public floggings and hangings, these were people that were only a couple generations removed from the Salem witch trials. And this was really before the birth of our nation, that these were cutting edge technologies for enacting reform among prisoners. So this is certainly under a different system of government in a different society. So the thing about solitary confinement is that because mental health issues often already pre-exist in so many offenders, it can be really hard to determine what mental health issues an offender is experiencing that predate imprisonment and predate solitary confinement, and which are the result of the exposure to solitary confinement. But studies show that the majority of those who experience solitary confinement end up reoffending, and at a higher rate than the overall population of the facility. There is an amendment that the committee should have received on this bill, and it was proposed by the Commissioner of the Department of Corrections. In OLS, I guess both I and OLS overlooked a portion that we were striking in section 1, went a little heavy with the Sharpie there. And it turns out that section 1 in part gives the Department of Corrections the authority to discipline whatsoever. And the intent of this bill is just to remove solitary confinement as a method of discipline. So there's a variety of other ways to discipline an inmate. And as it turns out, the State Department of Corrections is not using solitary confinement to discipline inmates. They do use solitary confinement, but for reasons other than discipline. So if someone is a safety risk, they're at risk of harming others, or maybe others are at risk of, or likely to harm them. There may be health issues. The current pandemic is certainly an example of how isolation can prevent the spread of disease. So there's a lot of reasons why solitary confinement has benefits in a correctional institution and probably in life in general. But as a form of punishment, it's not a regular practice anymore, and it's not considered appropriate. But I look forward to hearing the commissioner's testimony in that regard, because I know that she's, if she does plan on testifying, I know that she's obviously the authority on the system that is used in the facility to determine who's given solitary confinement and for what reason, and how that decision's arrived at. Also, there's a misunderstanding that I'd like to address, which is the belief that Section 2 would repeal the ability for the county facility to discipline in any manner. This is not the, unfortunately, because Section 2 is a straight repeal, it doesn't print the language in the law. But you can look it up online if you like. But Section 2 is not what gives county facilities the authority to discipline. In fact, Section 2 very specifically gives the county authorities the authority to discipline when a prisoner refuses to work. So for example, in the cafeteria, in the laundry center, if a prisoner refuses to work, then Section 2 repeals the authority to give them solitary confinement as a method of discipline in that situation. And that's one of the laws going back to the 1800s, when typically next to the jail, you'd find a field, maybe they'd be building things, maybe their labor would be farmed out to nearby businesses as a way of paying back their debt to society. And that's not something that's really going on anymore in the facilities. And the county facilities have, by statute, rulemaking authority where they can determine how they will discipline inmates. And in essence, Section 2 repeals a sort of like appendix. It's a section of law that's not being used anymore. It's not necessary. It doesn't really have a purpose. And we've already found workarounds where we've written new laws since then that enable the county facilities to handle issues like this in other ways. And additionally, because Section 2 repeals the county's authority to punish people who refuse to work, you can see that this isn't the section of law that gives the counties the authority to discipline whatsoever. Otherwise, we would never be able to discipline people for violence or attempting to escape, because that's not delineated in the RSA that's repealed in Section 2. So there's a lot of different ways that someone could be disagreeable or hard to work with when they're incarcerated, aside from just refusing to do laundry. And because the RSA in Section 2 was written in the 1800s, and times have changed, and so much has changed in the way that we really do corrections on this planet, it's just outdated. The terminology doesn't work. It doesn't fit into their program anymore. So I think that that's all that I really wanted to communicate to the committee. I really encourage you to look up the RSA that's repealed in Section 2 to get clarification on the archaic and outdated and unnecessary language. Thank you.
Thank you for your testimony. Are there any questions? Representative Spillane has a question.
Thank you, Mr. Chair, and thank the member for taking my question. I actually have 3 questions, but I'll start with the first one, which is that I do not see an amendment, and I know that I'm substituting on the committee, but you had mentioned an amendment, which I assume would unstrike the words "and may punish and convict guilty, insolence, or ill language to any officer of the prison for guilty of obstinate and refractory behavior," period, giving them the ability to punish, but taking out the method of punishment. But I don't see that amendment in my packet, and I took everything that was available and I don't see it. So I'm just wondering if that actually got drafted and is available to people today and was going to be offered today, or if it's an oversight.
Thank you for the question. In our committee, the committee assistant emails out amendments to the list of committee members. And I'm assuming that, I don't know how recently you were assigned to be a sub today, but I'm assuming that when that went out, you weren't copied, but I'd be happy to send it to you in whenever we're done talking. I suppose whenever I'm done answering questions, I can forward that to you because I can't do that many things with my brain at once. But the amendment language was drafted by the commissioner of the State Department of Corrections. So that way we can have confidence that it fits in with what they're doing at their facility.
Thank you. Follow-ups?
Follow-up question.
does this in any way impede the Department of Corrections, either at the county level or the state level, from using solitary confinement to protect the prisoner?
I think I opened a program on my computer by accident. No, thank you for the question. It does not impede the use of solitary for other purposes. And that kind of goes back to a lot of the rules that we have in place dictating how our county and state and prison facilities are run, is mostly administrative rules that go through JLCAR, for example, and they're not really in the RSAs anymore. And that's kind of what makes this set of RSAs stand out, is that they speak to really specific situations, specific problems with specific, really controlled ways of addressing them. And that doesn't fit into the overall scheme of how we're operating these correctional institutions anymore. I hope that makes sense.
It does, and one final follow-up.
Further question?
The last one that I had was in the repeal of section 2. I'm trying to write it correctly. At the county level, would this actually repeal them from being able to punish in any way for refusing to work? Or is this only taking the option of solitary confinement out of the list of options they have for refusing to work? Because I know that I still see the prisoners out collecting trash on the side of the highway and they're working.
Thanks for the question. You broke up a little at the beginning. I'm assuming that's my connection, but I think that I understood your question. A different RSA in the same section of law gives the county facilities rulemaking authority through the commissioners, and they're free to set rules for their facilities as to how they want to discipline inmates. So I hope that clarifies. Like this, that's what really makes this sort of like the appendix is. I think you're muted. Yeah, you're muted.
Further question, Representative Glenn?
Oh, yes.
All right.
Why did I mute?
My other question. Oh.
That's right. It should stay muted. My other part of the question that you missed when I asked it was, does this actually take away from their ability to punish for not wanting to work or refusing to work? I don't care about all the other ways they can punish people for other things they do wrong. I don't want to take away the ability for the counties to punish people who refuse to work on a work detail, because we do still send people out on work details. And they should be able to be punished for not going out on the work detail.
Is there a question there?
Yes, I'm asking, does this remove the ability to punish at all for refusing to work?
Thanks for the question. The answer is no. I hope that the way that I'm phrasing my answer makes sense, but no, this does not remove that authority.
Thank you.
Are there any other questions from the committee?
Mr. Chairman.
Representative Wallace.
Thank you, Mr. Chairman. Thank you for taking my question. Will this eliminate the practice of close or solitary confinement or just the term?
Thank you for the question. I'm a little confused. Can you, you said the practice or just the term, are you asking me if I'm cleaning up vocabulary in the RSAs? Is that what you're asking, or am I misunderstanding your question?
Thank you, Mr. Chairman. Well, it's pretty straightforward. Looking at the amendment and looking at the original bill, and based on what you said, it's unclear to me if this is just going to eliminate the term close or solitary confinement. And by your testimony, you said it would still be able to be used for the purpose of protecting an inmate. So the question remains, will this eliminate the practice of close or solitary confinement or just the terminology?
Thanks for the question. I think my answer is that it does not eliminate the terminology and it does not eliminate the practice. So neither, because I think there's just a misunderstanding about the bill in general. The bill does not eliminate the practice of solitary confinement. It eliminates, it repeals language and rewrites language that in the 1800s gave superintendents and people running correctional institutions the authority to confine people who refuse to work or to use solitary confinement as a form of punishment in for other activities. And as I said earlier, the Department of Corrections is not using, and when I say the Department of Corrections, I'm referring to the state facility. And then when I say the county facility, I'm referring to the counties. So the Department of Corrections at the state level does not use solitary confinement as a punishment. They use solitary confinement for protection, for health, to limit the movement of a prisoner who's likely to be violent or cause other problems in the facility that warrant confinement. They have a system that I hope when the commissioner speaks, she's asked about the grading system, but they have a very thorough grading system set out in rules that were approved through JELCAR to determine when an inmate should be confined. And as I understand it, multiple staff members are required to evaluate the prisoner separately so that the system can't be gamed and there can't be someone to like prevent someone from who maybe has a personal problem with an inmate to prevent them from sending someone to solitary as a punishment when they just maybe have a personal problem with them. So multiple people need to be involved in evaluating the prisoner. There's a grading system. The prisoner is given certain ratings on certain fronts. For example, their propensity for violence, things like that. Also what's taken into consideration is the reason that they were incarcerated in the first place, the severity of that crime. And those are the criteria that are used to determine who goes to solitary, and none of the criteria are if they need to be punished for something. So the Department of Corrections is not using is not taking advantage of what current law allows them to do. And that's one of the reasons behind a repeal. I hope that that clarifies.
Yes, thank you, Mr. Chairman. And if I might ask, Representative, what was the impetus for this bill?
Thanks for the question. I was thinking about that today and I couldn't remember, but commonly I'm searching for something else on the GenCourt website, and then I stumble across a dumb old law. And I'm like, wow, this law is dumb and it's old, and we should repeal it. And then come September, I file a bill. And that's usually how things go. If you look up the RSA that's repealed in Section 2, the terminology is really entertaining. I guess I don't have it in front of me, but refractory, stubborn, refuses to submit to work. These are, rules, words from a different society with different standards. And while there's certainly documents that were written a very long time ago that are really important to us today, and we want to preserve them and continue to live by them, there's obviously rules that we'd like to get rid of over time as we learn better. For example, in the time of the Salem witch trials, there were a lot of concepts and beliefs that people had back then that were not accurate. Lives were lost as a result of these misunderstandings. And it's always incumbent upon a good society to evaluate the laws that it has in place and update them. And I'm hoping to follow in the footsteps of the commissioner in updating the existing laws to reflect what's actually going on in our facilities.
Basically, has a question.
Yes, thank you, Mr. Chair. Thank you, Representative Bolton, for taking my question. In the amendment, there is a line that says that the commissioner may use appropriate correctional best practices in responding to violent behavior, escape threats, rioting, and behavior that adversely affects safety, security, or facility operations. Are those best practices going to be part of the rulemaking process?
Thanks for the question. I believe that they already are. And that's, I think that the commissioner looked at this bill as an opportunity to update existing law to cover things that probably weren't considered, either weren't considered in the 1800s or were delineated in areas of law that have since been repealed. I know that when this little snippet on solitary if you refuse to work was put into place. There was also that little bit about if you're really fussy, we'll only feed you bread and water. And then there was also at the time another section of law that dealt with how to handle people who try to escape, what happens to them once they're captured, who's to pay for the resources necessary to find them. And all of that's been repealed since then. So that is covered in other areas of law now. And it's just, I mean, in their rulemaking process, and it's just necessary to update the law to reflect that.
Okay, so follow up. I just want to make absolutely clear that what's going to be going into statute is pretty general, and I just want to make sure that there's going to be something much more specific in the rules.
There is, yeah.
Thank
you.
All right. See, I see no other hands up in the committee. Thank you very much for your testimony.
Thank you.
John, who do we have?
Check, Mr. Chairman. Mr. Chairman, if they could raise their hand if they are.
Yeah, it's the members of the public, if someone's out there and wants to speak, we have one. Helen Hanks.
Yep.
The Commissioner of the Department of Corrections. Welcome.
Good afternoon, honorable members of the committee. Again, this is Helen Hanks, the Commissioner of the Department of Corrections. For the record, I am in my office with the door closed alone. I thank Representative Bolden for bringing this piece of legislation forward. You'll see me signed in opposed. My opposition was to the original bill, not to the proposed amendment, as we did work collaboratively on trying to provide some current language representative of the state of New Hampshire. And I appreciate the adjustment because we are a rehabilitative organization and we should be using appropriate correctional best practices. And to Representative Bixby's comment, we want to be careful not to overprescribe in law and not be able to grow as a state Department of Corrections as those practices adjust. But if you do the research, when you do the research, I know you will, as you likely have done before today, you'll find things like the Department of Justice published guidelines on the use of restrictive housing. So the term solitary confinement, we don't use that term in state corrections. You'll see in my testimony as submitted at the beginning of this week, or it could have been last week, I do lose track of time at the pace in which we work here in the state of New Hampshire, that we changed significantly as far back as 2005 with regard to our practices as a result of very appropriate cases brought forward, and those practices have not changed. In fact, when you go to sites such as the National Commission on Correctional Healthcare, American Corrections Association, when they define those practices, it's 22 hours or more locked in a cell. We haven't engaged in that practice in more than a decade, and nor should any correctional agency do so in the future. Those classification rules, as Representative Bolden referenced, those are available all under the correctional rules, Chapter 400. They talk about how we analyze and assess individuals. With regard to the section of law here, discipline, when Representative Bolden and I first discussed this, I had not realized that I had agreed to striking all my authority to engage in discipline. So I want to appreciate her publicly for allowing me to make sure we maintain safe correctional institutions for the men and women incarcerated in the state of New Hampshire. And I would also point you to RSA 21H13 rulemaking. It describes all the rulemaking requirements of the state agency, and we have been updating those rules and moving them forward, both at the behest of this committee and other members of the department and constituent groups. You'll find that in section 21H14, however, we asked to make, and you have maintained this privilege under law, that the behavior of, and it's the term in law, inmates, is not prescribed in rule writing. And I just want to point out to you, for example, the agency has to be nimble in response to the activities within the agency, and to try to engage in rule writing to predict behavior would be a significant challenge. Most recent example is we have individuals who are remitting letters on K2 soaked paper. I would not have predicted that 6 months ago. So we have to engage in behavior and discipline standards for that type of activity. It's both adverse to our residents and obviously the introduction of contraband such as substances of abuse create for inappropriate environments with people under the use of those illicit substances. So I'm careful that the discipline rendered should be rehabilitative in nature. The behavior needs to be the behavior guidelines, which are published internal procedures and certainly available to the public, are available and people understand what those standards are, so we're clear. Again, I know this committee has likely read my testimony. I would rather give you and afford you the opportunity to ask questions and follow up with any additional information, but I believe the proposed amendment helps the state of New Hampshire and the Department of Corrections get to more appropriate language representative of 2021 and future forward looking.
Thank you. Any questions from the committee? See none. Thank you very much for your testimony.
Mr. Chairman, I don't see any. I do see 4 phones listed here. I don't know if they're just listening, or I think it is, if Representative Muse could help me, I think it's *9
Mr. Chairman.
to raise your hand with a telephone.
Chelsea Manning.
Chelsea Manning signed up to testify, and I see her online, we shall probably call her.
Yes.
I believe it's *6, Representative Byrd.
Oh, okay, because I know there was one for, mute and one for raising the hand. So if one of the phone people do want to speak, if they could press *6 or 9. I know one of it does both.
Ms. Manning
either.
did raise her hand.
But yes, I see Chelsea Manning.
Chelsea Manning, you have 2 minutes.
Whoops, where did she go? Oh, there she is. All right. Bring her back, allowed to talk for Mrs. Manning, or Miss Manning.
Unmute. Okay. Thank you, members of this committee. Good afternoon. I am Chelsea Manning. I am a security consultant and researcher in machine learning and artificial intelligence. I'm also an activist for incarcerated people and for unionizing in the workplace. Previously, I spent 7 years in prison following a high-profile court-martial. I was sentenced to 35 years, and subsequently, I was commuted by President Obama. For another year, a few years later, I was confined for 1 more year for civilly confining for resisting a federal grand jury subpoena to compel testimony. In the years that I've spent, in total, I've spent 403 years in various forms of isolated confinement, including administrative segregation, maximum security, disciplinary segregation, the entire gambit of various types of confinement and its different names used by the prison system in the United States. In both 2010 and again in 2019, my conditions were investigated by the United Nations Special Rapporteur on Torture. Subsequently, there was a report done that designated that approximately that anytime that you have 15 days or more of confinement that is more than that is any time period of around 22 hours per day in isolation would be considered torture by the United Nations. In the years since my confinement, I have developed complex PTSD. I have been in years and years of therapy. I have difficulty with relationships, even with people before confinement. And this is despite having a full-time job and a lot of resources, a lot of access to the public and whatnot. So I only just want to mention that there are long-term consequential effects to being held in isolation and this form of confinement. And I just want you to consider that the long-term effects that this has, whether it's for any reason whatsoever, it significantly impacts one's life far beyond actually being held in confinement. And just imagine the people that don't have the resources and the access the incredible access to these resources that I have had must go through. That is the end of my testimony. Thank you very much, members.
You've had your 2 minutes. We thank you for your testimony. Are there any questions by the committee? I see none. Thank you very much for your testimony.
Mr. Chairman, I see no further hands or telephones with their hands up, but I do see 4 telephones listening.
Then I guess we will close the public hearing on House Bill 557. Representative Moose,
John, hands up.
whose hands is up?
Bourdonnais.
Who's?
Bourdonnais.
Yes.
Representative Bourdonnais, you have a question?
Well, actually, I have not yet received the amendment to this bill. Is it possible to get the administrator to send it out to the committee?
Well, let's go send it again.
Clerk is resending.
I received one very quickly from Brad, so you might get it right in a few minutes.
Representative Muse, would you do the honors?
Yes, for House Bill 557, we had 101 people signing in support, and we had 4 people sign in opposition.
Can I correct that? One of the 4 was Commissioner Hanks, and she retracted that. So it should be 102 to oppose 3.
All right, we'll close the hearing on House Bill 557. We'll be in recess until 2:30. We'll be in recess until 2:30.
Let's do this.
Thumbs up or thumbs down from anyone? No thumbs up? Right. At this time, we are opening the public hearings on House Bill 123. On House Bill 123, granting immunity from prosecution for reporting a sexual assault. That will also be heard with House Bill 546, relative to 911 immunity for reporting that a person has been a victim of a violent crime. Representative O'Hearn, I see your hand is raised.
Yes, I can just barely hear what you're saying. I don't know if those mics are not all active or something, because I can just barely hear you, Mr. Chair.
The chair does have his own microphone right in front of him. That's on. Do the other members at home are having trouble hearing me?
I'm having trouble hearing you here, but not now. I think the mic was just away from you, Mr. Chairman.
Can the members hear me?
Yes. Yeah, I can hear you fine.
Representative O'Hearn, can you hear me better now, or?
Yes, again, thank you.
Okay. Representative Klein Knight, will you be introducing House Bill 123?
Yes, thank you, Chair.
Well, you're now recognized.
Thank you. House Bill 123 is a repeat from last year. It passed with consent, 19-0. It was worked on by both Representative Welch and Representative Panelakis last term. And there is going to be an amendment introduced by, hopefully by our chair. So I'm not sure if I should speak to that or we should wait till exec session, but I just wanted to get that on your radar, and that would make the bill a little stronger for victims that are, they shouldn't have to prove that they're victims in that moment to receive medical care. So that's what the amendment does. And we had, for people that weren't in the committee last year, really compelling stories of women, not just women, but mostly from women being held basically prisoner and being raped repeatedly under the guise that they couldn't leave and get themselves the help that they needed because that they were conducting in a form of a prostitution. So it's used by harassers to keep their victims compliant. And that means we get less reports for crimes on these issues as well. So hopefully this makes it past this time, and I'm open to any questions.
Seeing no hands raised, I want to thank the representative for her testimony. And just to clarify, Representative Knight, if you do wish to ask any questions, you will be permitted to ask questions, but if you do, specifically only in regards to House Bill 546. So please, if you do ask a question, open the question by saying specifically regards to House Bill 546.
Thank you for the clarification.
Representative Bolden, will you be introducing House Bill 546?
Yes.
You are now recognized. And that same introduction in regards, same statement I made to Representative Klein Knight would apply to you, but in regards to House Bill 546.
Thank you, Mr. Chairman. Thank you, committee, for hearing my testimony again today on House Bill 546. So this is a bill that came through this committee before COVID, and it never made it through the Senate. because of the pandemic. I believe it was voted 18-2 ought to pass originally and was on the consent calendar at the time. And for what it's worth, the bill that was just heard was, I believe, unanimously passed by this committee before COVID and was on consent. Both of the bills operate on the back of the concept that already exists in New Hampshire law. I know that the makeup of this committee has changed a lot, but one thing that stayed the same more or less over the years has been the presence of Representative John Burt. And he would surely remember sitting through the subcommittee meetings on the 911 immunity law that we were trying to pass back then. And I think the chairman of the subcommittee was a legislator who's not here anymore. I think Rennie Cushing was on the subcommittee, and so was Representative Burt. And the focus of that subcommittee was what to do with a proposal to give immunity to people for the charge of drug possession if the evidence for that charge is found when they report an overdose. And something that 911 personnel were running into at the time was bodies in snowbanks and bodies alone in rooms with just a driver's license left and all the drug paraphernalia cleaned out. And the problem at the time was that people would, unfortunately, when faced with the choice between getting their friend, if you want to call it that, medical help when they're overdosing or saving themselves, they would save themselves more often than not. And so ultimately, when Governor Hassan was governor, Senator Hassan was governor, the Republican-led House and Senate passed a law to give immunity for the charge of possession if the evidence is found when someone's calling 911 to report an overdose. So it's a really well-written area of law, and this bill just amends that area of law to include immunity from the charge of possession if you're reporting a violent crime in general. And then the bill references a specific list of violent crimes. So the way that the existing law works is if you call the police and you say, I'm reporting an overdose, and they show up and there's people tied up in your basement, you're going to get in trouble for that. And if they show up and you have a meth lab, you're going to get in trouble for that. But if they show up and you have such a small amount of drugs on you or drug paraphernalia that it only qualifies for the charge of possession, then you're not going to get in trouble for that. And the goal is to encourage, with the existing law, encourage people to communicate with police and communicate with 911 and save people's lives so that they have the opportunity to turn their lives around. I've certainly met people who've gotten Narcan 5, 6, 7 times in their lives, and they're now pastors or youth leaders, and they finally had the opportunity to turn their lives around. And the data, the law that was originally passed had a sunset in it. And there was a GOP bill in a subsequent year to repeal the sunset because data was showing that the existing law was very effective in encouraging people to call 911 in the event of an overdose. So what I had in mind with this bill and what I communicated to the committee last year was that we should extend that to people who are either have been victimized themselves or may have information that they'd like to share with police about a crime. Because as we know from, at a minimum, watching gangster movies, that oftentimes in certain communities, it's less important that someone's committed a crime and more important that you maintain your freedom from jail or something like that. And people are not willing to communicate with police. And there's so many articles on the Union Leader, Manchester Inklink, and so forth, where Manchester police, because that's where I live, are complaining that there are people showing up at the Elliott Hospital with stab wounds, gunshot wounds. They won't talk. They won't tell anyone what happened. And how are they supposed to address that? These are real victims of a crime. There's someone who's committed a crime, who's walking around free. And it's because there's something going on in the victim's life that they're not willing to cooperate with police. And for whatever reason, they've decided that they'd rather that the person who hurt them go free than have to interact with police because of whatever's going on. And interestingly enough, we heard this bill, well, your committee, our committee, I'm on the committee now, heard this bill January of 2020 before the House really shut down over COVID. And at the time, you know, I was proposing this bill based on complaints that I'd seen in the news where people weren't cooperating with police, and just that it seemed common sense that if someone's willing to cooperate with police to report information about a bank robbery that they'd overheard someone bragging about, or if they wanted to report that they'd been assaulted or abused in some way, raped or something like that, it just seemed like common sense that someone shouldn't be arrested if the thing they're being arrested for is just really small and insignificant. It doesn't involve the victim. But then interestingly enough, it was probably like 3 or 4 weeks into like, I guess what I would call peak COVID, you know, sometime in March, we came home from getting groceries, which we were only doing about every 2 weeks at the time, and turned the corner near our house, and there were 2 men on the side of the road in the grass fighting. And my husband, I was the passenger, my husband pulled over and started honking, like telling them, stop it. You know, he's just reacting like, what do we do? But we can't just drive past this. You know, this isn't New York. You don't just drive past something like that in New Hampshire. And so he pulled over, he's honking, he's yelling at them. And we looked closer, and the guy who was on top had a full champagne bottle in his hand and was beating the other guy in the face. And there was blood everywhere. It was horrifying. And a lot of you know me, I'm a little nuts. I got out of the car, and the guy who's on top with the champagne bottle leaves. And we were in touch with 911 at the time, and they said that they were coming. And I'm saying to this guy who has blood all down his face, down his clothes, all over the things he's carrying, I'm like, please wait. There's an ambulance coming. You probably need stitches. He seemed to be in shock, and he just walked away, like into our neighborhood in the direction we were going. So I followed him, and I was like, my husband's just going to keep driving behind us. He knows me. He's not going to talk me out of this. If you're walking this way, guess what? We're going to pass by my house. We can get you some paper towels. And I was trying to reason with him, and I was like, please just wait for the ambulance. You might have a concussion. You shouldn't go to sleep if you have a concussion, etc. And I could tell based on how he was dressed and the things he was carrying that he might not have a place to live. And he repeatedly said to me, I don't want to talk to the police. I don't want to interact with them. I don't want the police around me. I don't want them in my life. I'm not going to talk to the cops. You need to leave me alone, lady. And I refused. And then somewhere along our long walk through my neighborhood, the police caught up to us, and eventually an ambulance. And I said to the police, will you please don't give him a hard time, because I guess something's going on, and, you know, he doesn't want to interact with you. And anyway, later on, because we were witnesses, the police called me and asked me if I would give my statement over the phone as to what happened, so that they could pursue the person who was eventually caught and arrested for assault. And they told me that the person who was assaulted refused to cooperate. So I was the only person who could really speak to what had happened that day, aside from my husband. And it's just funny how, you know, I put in the bill, and then a couple months later, when COVID had already eaten the bill, or the Senate, you know, wasn't going to take it up, as they did with so many pieces of legislation last year, it's funny that I would walk right into a situation and basically live out the concepts in this bill. So I'm happy to take any questions about how it's worded. I'm sure the bill looks a little complex, but in reality, it's just tapered onto the edges of the existing law that relate to calling in an overdose. And you know, again, the idea here is for someone to be able to call in information they have about a burglary, a robbery, a violent crime against another person, if they've been victimized, for them to be able to report that and feel comfortable doing so. So I think that's all I wanted to share with the committee, and I'm happy to take any questions.
Thank you, Representative, for your testimony. If you don't mind, the chair would like to inquire of a question. On the bill, on line 6, and then again on line 9, it uses the verbiage, another person. So is this intended to apply when someone themselves is a victim of a violent crime, and they wish to report the crime? Because if it says another person, wouldn't that exclude an individual calling on their own behalf when they are the victim?
Thanks for the question. So section 2, or Roman 2 refers to another person, and Roman 3 refers to the person reporting. So Roman 3, 17, line 17, in good faith and a timely manner reports that he or she has been a victim of a violent crime, or is the victim in a good faith and timely report of a violent crime. So the idea is that the caller and the subjects of the crime are covered. The idea being that, someone might be reporting a rape or an assault or something, but they might also be reporting a theft, and maybe the victim of the theft isn't even present. Maybe, someone breaks into my house and steals something, and then they brag, and someone else hears about it, and then that person would call in by themselves, so they would be personally covered. But then also, if someone's personally victimized and maybe there's also a witness to that incident, then either the person who's victimized or the person who witnesses it could call in. I hope that clarifies.
It does. It did raise a, but we can talk about the rest in the executive session. Thank you for your testimony. Seeing no hands raised, if the representative is excused. If any members of the public who are in attendance who wish to testify at this time, please raise your hands. Testimony from the members of the public will be limited to 2 minutes. The chair now recognizes Dr. Joe Hannon. And could the witnesses please specify whether they're testifying on behalf of HB 123 or 546 or both?
Thank you, Mr. Chairman. My name is Joe Hannon, former legislator, retired doctor, and I'm testifying in favor of both bills, 123, House Bill 123 and the 546. I was around I was in the legislature when the original 911 immunity bill came through and was helpful in getting that passed in some way with many of you on this committee. And I'm glad to see that this has gone to a different level. I regularly work with people doing syringe exchange and in the recovery community who have been victims of violent crimes or even sexual assaults and have not reported these crimes. I've actually personally witnessed people being assaulted or sexually assaulted, not witnessed sexual assault, but witnessed people being assaulted or being the victims of sexual assault. And I've treated some of these people medically in some of my training in the past. None of them that I've met wanted to come forward and file charges and prosecute the people who had assaulted or sexually abused them because of fear of retaliation for either drugs or prostitution predominantly. It's also very clear that sex workers in general are very reluctant to come forward, as are all victims of sexual violence. We know that the numbers of people who actually come forward and report sexual violence are dismally low. It's in the teens in many studies that you look at of how many people actually report these crimes. And in instances of people in the sex work industry, that's even lower. I think we need these laws desperately to keep people safer and not just protect people who are using drugs and sex workers, but to protect other victims who may be victimized by people who were not put in jail because they victimized someone who just happened to be doing drugs or in sex work. So this doesn't just protect them, it protects society as a whole. And I implore you to please pass both of these bills. Thank you. Under 2 minutes, there we go.
It's the first time you made it under 2 minutes. Representative Klein, you're recognized for a question.
Thank you, Chair. And I'm speaking on House Bill 546. Thank you for taking my question. Do you believe by introducing this kind of legislation, you'll see a reduction in crime?
I don't know if I'd hope so, but I definitely think you'll see an increase in reporting of crimes, which could lead to less crimes being perpetrated in the future. I think people are less likely to commit a crime if they know that that victim is not afraid to come forward. So yes, I do think that will maybe be the case in many of these instances.
Follow up?
Representative Knight, you're recognized for a follow-up question?
Thank you. Do you think there's potential then for more data gathering on this subject?
Oh, absolutely. I mean, right now we don't hear anything. I mean, even just people who are not in the sex work field or using drugs don't come forward in such high numbers. We don't know about a lot of these, specifically sexual assaults. Most people are more inclined to report an assault, a simple assault or assault and battery if they're not involved in those areas. But I think this will definitely increase bring it to light. Light is the best disinfectant. So people being able to come forward definitely will help solve some of the problems.
Thank you.
Thank you.
Seeing no hands raised, I want to thank the witness again for his testimony.
Thank you all. Have a good day.
The chair now recognizes Lynn.
Oh, yep, she's unmuted, Mr. Chair. Or he.
Hi, good afternoon, Mr. Chairman. This is Lynn Chalette.
You can hear. You're now recognized.
Okay, wonderful. Thank you so much. Good afternoon, Mr. Chairman and members of the committee. My name is Lynn Chalette, and I am the Executive Director of the New Hampshire Coalition Against Domestic and Sexual Violence. And I'm here to speak in support of House Bill 123. Thank you for this opportunity. We fundamentally believe that the fear of being arrested should never prohibit any victim from reporting that they have been sexually assaulted. And this protection should apply to any rape victim, including those who have engaged in prostitution. We generally support this legislation, including the amendment that was referenced by the sponsor in her opening comments. And I'd like to touch just for a few minutes on that specific language, less than 2 minutes. The reason that we support this amendment is the bill as drafted currently violates the spirit and the letter of the law of the Federal Violence Against Women Act. The Violence Against Women Act is a federal statute that grants funding, rights, and protection to victims of domestic and sexual violence. Specifically, when VAWA was passed in 2005, it includes language that prohibits states from requiring victims to participate in the criminal justice system or to cooperate with law enforcement in order to be eligible to receive medical care and forensic evidence collection. So the coalition would support an amendment that removes 2 pieces of language in this bill. First, removing the requirement that provides that a victim must cooperate in an investigation that's in the legislative intent, and also in Section 7, removing the language that requires a victim to assist law enforcement to identify the perpetrator. The goal of the Violence Against Women Act was to make sure that any person who's sexually assaulted is able to get critical medical care, screening, and evidence collection. Victims face so many barriers when they come forward to report a rape or to report domestic violence. And it's critical that this state legislation mirror the protections provided to victims on the federal level to ensure that they have access to that care. So I appreciate the opportunity to come before you today. And with this amendment, I bet that's my timer. So thank you very much for your support and consideration today.
I want to thank you again for your testimony. Representative True, you're recognized.
Thank you, Mr. Chair, and thank you for taking my question. In section Roman numeral 8 of the bill, I don't understand it. Victim seeking medical treatment doesn't need to make a report or cooperate with law enforcement. If somebody's going to a hospital in need of medical treatment, aren't they going to get medical treatment at the hospital? Or is the doctor at the hospital going to say, you must cooperate with law enforcement before I treat you? I don't understand that whole scenario.
Right. Thank you for your question, Representative. So the scenario that we're concerned about is if someone who is sexually assaulted comes forward and in the process of receiving that care tells the doctor or tells the nurse or the sexual assault nurse examiner that they were engaged in prostitution when they were sexually assaulted. The goal of this bill is to make sure that that individual can still receive the care and the evidence collection if they want it, and that they won't be at risk of being arrested for engaging in prostitution because they reported a rape. So the scenario you're describing is exactly what we want to prevent. We want to make sure that any evidence that's collected or any statement that a victim makes about engaging in prostitution is not used as evidence in a prosecution against them.
Thank you. Seeing no further hands raised, I want to thank the witness for her testimony.
Thank you very much.
At this time, the chair recognizes Joseph Ebert.
Good afternoon, members of the committee. My name is Joe Ebert. It's E-B-E-R-T. I'm a captain with the New Hampshire State Police. I oversee the Investigative Services Bureau. So thank you very much for giving me the opportunity to speak today. I want to say that I will be speaking to 546 and 546 only. And I want to start by saying that we absolutely, as a division of state police, support the notion of what's trying to be accomplished. But as we reviewed this, the one thing I wanted to bring to the attention of the committee is it does not appear as though there is a restriction on the amount of narcotics that somebody could be not prosecuted for. So in other words, when the bill was introduced, there was discussion about a small amount of drugs. I think everyone can understand why a small amount of drugs is clearly not outweighed by somebody's health. And not that a large amount necessarily is, but with there being no top end on that, that was something that we wanted to bring forward to the committee to at least have a discussion point that perhaps there should be some limitation on the amount of narcotics that you could be forgiven for possession in this given scenario. So having said that, thank you so much for the opportunity to address you today, and I'm certainly willing to take any questions that you may have.
I want to thank you for your testimony. Representative Gathright.
Thank you, Mr. Chair. Thank you for taking my question. Do you have an amount in mind that you are thinking about?
I don't, ma'am. Thank you for the question. I don't. I simply wanted to bring forward as a point of discussion. It's an incredibly difficult topic to try and weigh out, the value of reporting harm that has been done to somebody and giving somewhat of a free pass on a possession of some level of drugs. I'm not sure what where that break-even point is, or if it exists. I simply wanted to bring forward to the committee for discussion that topic.
Thank you.
Representative Spillane, you're recognized.
Thank you, Mr. Chair, and I thank you for taking my question. This bill is not replacing the act we already passed that gives somebody the ability to report a drug overdose with immunity. I would imagine that we already addressed the situation of a quantity in that act. Did we not? And would there be no problem modeling this after that?
And so that may be a question that is best answered by the other members of the committee. I think it's a valid point, certainly. But again, as a topic of discussion, perhaps it is something that was already meted out through the process of committee work before. I'm not aware of what that committee work was on that prior bill.
Representative Klein-Knight, you're recognized for a question.
Thank you. Thank you for taking my question. I believe the sponsor, this is about HB 546, excuse me. I believe the sponsor, Representative Bolden, said that there's certain limitations already in this bill and that, there's certain things that you can go after someone for. And I just want to know, in your experience, when you go to someone that's really a danger, or more often than not, aren't there other crimes that you can find to go after them for?
So I answer both parts of your question, and perhaps Representative Bolden, I note that she did reference that. I didn't, when I looked at the bill itself, it seemed to reference 318B2. I looked up 318B2 and it talked about possession and possession with intent. So I didn't see, I know that she had said a small amount, and that's why I was referencing. I think everyone can understand a small amount of drugs is not nearly worth taking a risk at somebody's health. But I didn't see within that bill where there was a quantity that was regarded as being forgiven, for lack of a better term. So that may be somewhere else. So, and I apologize greatly if I've missed that, but I didn't see it within the bill. And in terms of when we respond to a call and whether or not there is there could be another crime that could be charged, what I would say is it's been my experience that when I respond to calls or when I'm in the presence of others who respond to calls, we charge people with the crimes that they have committed, and we aren't there to search for necessarily just a crime to charge. So it is what you're presented with at that time.
Representative Klein, now you have a follow-up question?
Yeah, I'm just trying to know what your rights are as well. Thank you. So it's just a scenario, you go in there, somebody called 911 and they have some possession on them and you can't convict them for that and you save the life. But if you think something else nefarious is going on in this home, when you look around, are you allowed to pursue a warrant or another avenue of conviction for somebody that is a criminal?
Yeah, absolutely. If there was probable cause that exists as you enter a dwelling to lead you to believe that a crime has been committed, you can absolutely apply for a warrant. I think what I was getting at was more, if you were to walk into a home and there was, say, 25 to 30 kilos of methamphetamine sitting in the home, is there a provision within this bill that says, that then again, I may not be aware of, and I apologize if I've wasted the committee's time on that, but is there a provision within this bill that says, well, at that level, at 30 kilos, there could be a criminal repercussion to this? But absolutely, once you're in a premises and you're, you may see evidence of another crime, you could certainly seek a warrant. But I think that from what I understand from this bill, I wouldn't be able to seek a warrant for any drug-related crime.
Representative Spillane, you're recognized.
Thank you, Mr. Chair, and thank you again. In a little bit of research, I think I found the answer to my question to you previously. Would you believe that there was a Supreme Court case, State of New Hampshire versus Brian Eldridge, that was decided on February 19th, 2020, in which the court has decided that the immunity afforded by RSA 318B 28-B 2017, which is the drug immunity that this is modeled after, that the immunity did not extend to possession with intent to sell. And that the Supreme Court has already decided that the immunity covers drug amounts that are up to but not including amounts that would be of that quantity to be considered intent to sell.
Representative Spillane, I thank you greatly for finding that case. We were certainly not aware of that, and that very much may answer the concern that we had, reference the quantity that could be available.
If you need to know the name again, it is State of New Hampshire versus Brian Eldridge, and you could be free to look that up.
Excellent. Thank you very much, sir.
Seeing, Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. I have a very good friend that's in law enforcement, and he was giving me just, some examples of some of the ways along the lines that you're addressing as far as, possible limits instead of it just being, I guess, just unlimited. Would you be able to give an example of maybe unintended consequence of what is meant to be a good thing? However, when you go into a home and, there's just bad things happening pretty much everywhere. And now, as you just said that, you're only there for this particular reason, but you see all these things and now your hands are kind of tied. Would you be able to give us like an example of maybe what you can see as an unintended consequence of that? or of this particular bill?
So I think where this bill only addresses the possession of a narcotic, and as Representative Spillane has mentioned, it appears to be limited via the Supreme Court to only simple possession. I wouldn't worry as much, Representative Rhodes, about being handcuffed by this particular bill. And the reason I say that is because it is specific to narcotics. And if I were to see evidence, or any other law enforcement officer were to see evidence of another crime that was being committed, they could either act on what is in plain view, or they could certainly seek a warrant and further the investigation that way.
Thank you.
Representative True.
Thank you, Mr. Chair, and thank you very much for taking my question. If I could just throw a scenario at you so I can get my head around the bill, especially given what I've heard is there may be a court case saying it only involves simple possession. If it only involves simple possession, then what is this bill doing? Somebody's been hurt. I've got drugs on me, but just simple possession drugs. If I call the police because somebody got hurt, you're probably not going to put me up against the wall and search me. You're not going to find the drugs on me anyway if I've just got simple amounts for simple possession. So what does the bill accomplish? Why wouldn't somebody call for simple possession? They wouldn't call if they've got a whole bunch of drugs in their house and they'd be liable for that. But for simple possession, wouldn't a normal person go ahead and call the police or call an ambulance?
Well, what I would say to that, sir, is sometimes individuals who are ingesting narcotics don't make the clearest decisions. And I think that what this bill, if I understand the aim of the bill, is to ensure that people know that regardless if they're nervous or not about the small amount of drugs that they have on them, that they are calling to report that assault or overdose. And that's certainly something that we're supportive of. We would never want somebody to, for the sake of a very small amount of drugs, put somebody else's health in danger.
Thank you.
Seeing no hands raised, I want to thank you, officer, for your testimony.
Thank you.
At this time, the chair recognizes Catherine Cooper.
Oh, where'd she go? Oh, down here, right. Disappear quick.
Thank you, Mr. Chairman and members of the committee. This is Catherine Cooper appearing on behalf of the New Hampshire Association of Criminal Defense Lawyers. I'm speaking solely to HB 123, and we oppose this bill. We oppose this bill because it invites false accusations. The bill creates an actual statutory defense to the crime of prostitution. It does not simply limit the gathering of evidence during a medical exam. The bill is structured in such a way that anytime a prostitute is arrested, he or she can claim that they were sexually assaulted and charges can no longer be brought. So we request that this bill be ITL'd because it will invite false accusations, have unjust consequences, and not actually help people who are working in the sex trades.
Seeing no hands raised, I want to thank the witness for her testimony.
Thank you.
Are there any members of the public who wish to testify that have not testified already? If so, please raise your hands. Seeing no hands raised, this time we will close the public hearing on House Bill 123 and House Bill 546. Representative Muse, would you like to do the honors on both 123 and 546?
On House Bill 123, we had 106 people sign in support and 3 people sign in opposition. And on House Bill 546, we had 87 people sign in support and 1 person sign in opposition.
Thank you, Representative Muse. The members at home, we are going to open up some executive sessions now. It would be highly recommended that you turn on the video devices. This time, we're opening the executive session on House Bill 123, granting immunity for prosecutions of prostitution for reporting a sexual assault. The chair recognizes Representative Welch to make the motion of ought to pass, and if we do wish to offer an amendment.
All right, I make a motion about to pass for House Bill 123, and I offer amendment 07608.
Is there a second?
I'll second.
That has been seconded by Representative Spillane. Representative Welch, wish to speak to the motion? Or are you offering an amendment? Wish to speak to the amendment?
I'm offering the amendment, and I'm not sure how to interpret it.
What the amendment does, and this is my interpretation of it, again, it's 2021-0760, is that if a prostitute or a sex worker were to report a violent crime to the police, that sex worker would be required to cooperate with the investigation. They basically would not have a choice. This eliminates that requirement. I know when this bill was presented last term, that was a concern that I raised. I know it was also brought to our attention that may also be in conflict with federal law. That conflict aside, I still don't believe that that's a good policy to compel someone to be forced to cooperate with investigation. And essentially, they could, under some circumstances, they could lose the option of having immunity by failing to cooperate. And I don't feel that that's voluntary. The idea is that the person's been a victim of a violent crime, regardless of lifestyle or anything about that. No one deserves to be a victim of violent crime, and also being forced to, at least compelled to testify or to cooperate, I don't believe is desire. I understand the logic of reports a crime to a police officer, to law enforcement, that is presuming that person would cooperate, but that is not always the case. However, this amendment would remove that requirement if they cooperate, but also apparently make it in compliance with federal law. Representative Byrd.
Thank you, Mr. Chairman. And I guess I'm just wondering on what Ms. Cooper said about if a prostitute ended up getting arrested, he or she, depending on who it is, could say, "Oh, great," and then the other person is going to go upriver. Is that a possibility?
Is that so? I believe that goes to the underlying. So the underlying bill, not the amendment, but.
Oh, that's true.
But just to answer that, because I did have that in my notes. So it is the intent of the general court to encourage a victim of sexual assault to report such crimes. So my understanding is this, in that scenario, the concern raised, I believe, by the testimony was someone is arrested for solicitation, prostitution, and then all of a sudden they say, well, I was the victim of sexual assault. And they're using that as a shield. What this law does is that the sex worker is reporting the crime. So in order to invoke this, they would have to report the crime. And therefore, so they're already claiming that they were a victim of sexual assault before they ever were in custody or arrested or anything like that. That's my understanding what the intent of this does. But that's more the underlying bill rather than the amendments.
Okay,
So
yeah.
we can
I'll-
discuss that further.
Yes, I'll talk about it on the bill. I do apologize. I forgot that we were just on the amendment.
Representative Gathright?
Okay, so you took out the piece here where it says, and assisting law enforcement to identify alleged perpetrator. That was line 10 and 11. Can you give me the rationale behind that?
So there's two rationales. One, the testimony we heard is that there's a federal law apparently that does not permit the requirement that a victim of a violent crime cooperate with law enforcement in order to obtain medical treatment. And I hope I'm wording that correctly. I'm going off of memory. That's the federal law issue. That issue aside, what this law would require is that if a sex worker or who's the victim of the violent crime were to report that they've been a victim to law enforcement, they're required to then cooperate with the entire investigation all the way through. Now, that doesn't mean that if they're served with a summons to appear in court, that they can ignore the summons. It just, in order to claim the immunity, they shouldn't be required to continue to cooperate with law enforcement. I understand it may appear counterproductive to report a crime, then not cooperate with the investigation, but at the same time, should that person lose the immunity claim by failing to cooperate?
No, but I think that the person should identify the perpetrator.
Excuse me.
Listen, I agree that they should, but I'm saying by making it a requirement that they do in order to maintain their immunity, to me, it's no longer voluntary. I mean, now they're doing it in exchange of not being prosecuted. And they're the ones that called in the first place. This is just a requiring to do that, but I do believe that, and I was opposed to that provision before I realized it was a violation of federal law, so. It's on both grounds that the amendment would solve that. But I hope if someone does report that they do cooperate. Representative Splain.
Thank you, Mr. Chair. If I could, I'd like to maybe throw out a scenario that I've been thinking of here that might explain why they might not want to identify the perpetrator after they've reported the crime. Would you agree that this amendment makes it now freer for the person who reports the crime to say report the crime, and then at some point after they've reported the crime and they've got their immunity, realize that the person that they got assaulted by had connections to, say, the Whitey Bulger family, and that their life was in extreme danger if they were to continue with the identification, and they might become afraid and not want to report it. And this would then allow them to say, you know, I've made my report, but I'm not going to go any further, and I don't want to lose my immunity.
It would extend to that scenario, and that's a great example. But at the same time, even much lesser examples, it's just out of whatever fear that they may have. I believe it's an option that they're not required. Again, that doesn't mean the police can't summons them as a witness. And if that person doesn't appear at the trial, the case is not going to go anywhere. The confrontation clause will require the charge to be dropped. Representative Sherwood.
Thank you, Mr. Chair. This is getting, for me, foggier and foggier. So, I'll make up the scenario. I'm obviously a scenario type of guy. A prostitute is working the streets and she sees two beat cops coming her way, and she's obviously working. And she says, "Thank goodness you're here, officer. I was just sexually assaulted." By who? None of your business. I was just sexually assaulted. I don't want to do anything else to let you know that. Maybe I should be checked out at the hospital. She's not going to be arrested for prostitution. She doesn't have to say who assaulted her. And she gets the medical attention she may or may not need. But she gets away with the crime by following this law.
Two things. To the point that you're making, that again relates to the underlying bill, not the amendment. So I guess, my point is, I can address that now, maybe we vote on the amendment, if the amendment, that, your point would apply whether the amendment's adopted or not, the underlying law. But just because someone has immunity does not mean they can never be prosecuted. If law enforcement is able to gather evidence independently of the person reporting the crime, they could still arrest and prosecute that person. They just won't be able to use the evidence they obtained by the sex worker reporting the sexual assault to law enforcement. So the scenario you're saying, where they're, a sex worker standing outside and two officers walk up, if they had independent evidence that whether it's surveillance, whatever, they, whether they claim, try to get immunity under this or not, I don't believe would protect them from being able to, they still could be arrested because the evidence was obtained independently. But again, that's the underlying bill, even with or without the amendment. So we can discuss that more maybe after we vote on the amendment. Representative True?
So the amendment itself says cooperation is not required.
Yes. Then Representative Bolden.
Thank you, Mr. Chairman. I understand that there's some debate over whether we can discuss the rest of the bill when discussing the amendment. And I hope that it's okay to debate the amendment by referencing the rest of the bill. And to expand on what you were saying, and this isn't my bill and I didn't co-sponsor, but I feel like I understand the terminology. It says on line 14, shall not be arrested, prosecuted, or convicted for a violation of this section. Line 15, if the evidence for the charge was gained as a proximate result of the person's reporting. And it's my understanding that the way that this terminology has historically been used in New Hampshire law, proximate meaning like direct result. So the evidence of prostitution would have to be acquired after the sex worker or what have you has already contacted police to report the sexual assault. So I don't know if that addresses Representative True's concerns, but the way that lines 14 and 15 read to me is that the interaction between the sex worker and police would have to begin as the sex worker reporting the crime. And then if during the course of that conversation, the police conclude that there's evidence for a charge of prostitution, they wouldn't be able to use that evidence to support that charge because they found the evidence during the conversation of reporting the sexual assault. So like a real life example would be someone's doing what they're doing with their life and then something goes wrong and the next day they work up the courage to walk down to the police department and make a report. And they sit down and have a conversation and maybe the police ask, well, what happened that put you in the situation of being in a car with this man? And then maybe she would say, well, I was prostituting myself. And that's the situation that I believe this bill and specifically lines 14 to 15 are intended to speak to, is that when that evidence is found.
Can you please suspend? Although you are making an excellent point to the underlying bill, I will say that that excellent point to the underlying bill, and that will also be relevant to the bill, whether the amendment is adopted or not, which we will discuss. I don't believe that that was relevant to the amendment, which simply relates to whether the sex worker reporting the sexual assault to law enforcement must cooperate. So, maybe we move the question on the amendment, and then we can discuss the underlying merits of the bill, which I think respect the members are having a healthy discussion, but it's not necessarily as relevant to the amendment. So seeing no hands raised in regards to the amendment number 2021-076, Representative Newman, are you with us?
Apparently not.
Where is he? Yeah, he's there.
I don't do it on purpose. Seeing no hands raised, the matter will now be put to question. If you are in support of adopting Amendment 2021-0760, please vote yea. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Welch,
Aye.
Representative Burke,
Yes.
Representative Spillane,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harriet Gaffray,
No.
Representative Bixby,
Yes.
Representative O'Hearn,
No.
Representative Wardenay,
Yes.
Representative Muse,
Yes.
Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
Chair votes yes.
Mr. Chairman, the vote is 19 yea, 2 nay.
By a vote of 19 yeas and 2 nays, Amendment 2021-0760H has been adopted. Representative Welch, you wish to move now to pass as amended?
Yes, I move House Bill 123 FN be ought to pass as amended.
Does someone wish to second that motion?
Second.
That has been seconded by Representative Spillane. Representative, Welch, I'll recognize you to speak. If not, I would let Representative Bolden pick up where I interrupted her.
Oh, that's fine. Let her go.
Representative Bolden, you may continue the excellent point that you're making.
Thank you. Well, I think the point I was building up to was about the amendment, but the bill, let me make sure I have that open. So again, it's not my bill, I'm not a co-sponsor, but I think I know what the words mean. And in the situation that I was talking about, if somebody's sitting in front of a police officer making a report, they've been the victim of a crime, the police officer is taking the report and it's revealed through the conversation that the person making the report was engaging in prostitution around the time that the crime happened, or just the result of the conversation with the officer when the report's being made, then the officer would not be able to use that as evidence to support a charge against the person making the report. It seems pretty straightforward. And so consequently, if now that the amendment's passed, I suppose the effect would be that if somebody gets scared, like the representative earlier was saying, Whitey Bulger's friend was the assailant, and they're not comfortable continuing, it seems like they would enjoy the immunity regardless, because the point is that they had to reveal that they were engaged in criminal behavior to make the report. And it shouldn't be dependent upon someone necessarily cooperating. It's just the fact that they had to reveal that they were engaged in criminal behavior to make the report about a violation against themselves. So thank you.
The matter is open for discussion. If anyone, Representative Marston, you recognize?
Thank you, Mr. Chairman. I just have a question of the last person that testified, who was a defense attorney, and she was against this bill. And I got the opinion that she thought that it could be manipulated. And I asked that question to any member here that might be able to answer that for me.
I understood that concern, and I believe Representative Burt and had the similar concern. And the concern was is that basically anytime someone is arrested or charged with prostitution, that they would try to invoke this defense, which I believe that's a legitimate concern, but I believe in this scenario, for this to apply, the sex worker is the person has to contact law enforcement. So in that case, if they contact law enforcement and report that they've been a victim of sexual assault, at that point, that person cannot be charged with prostitution. So I don't believe that, I don't agree with the testimony that scenario will become a problem because they're reporting it. Representative True had a good hypothetical that what happens if two officers are approaching someone that's working as a sex worker outside on the street, and they approach the person. That's the difference there. Number one is that person is not contacting law enforcement to report that they were a victim of sexual assault.
Thank you.
Representative Rhodes.
Thank you, Mr. Chairman. I think it's very important to point out that anytime that you're dealing with a sexual assault, reporting of a sexual assault, unless you have actual video evidence of the assault, it's really going to come down to a he said, she said situation. And in order for the person to actually be charged, you do have to have pretty overwhelmingly, you have to have like overwhelming testimony to be able to prove your point. So just to say, as the clock goes by, oh, I was assaulted by this person, you know, I like to think that the officer is able to tell signs of distress or not, or the validity. Thank you. So my friend over here had earlier. You have to be able to tell the difference, and a lot of that is determined by, well, one, the testimony, your body posture, your anger, and it is going to come down to what he said, she said, and you just have to you have to be able to prove that with your words. So I think a lot of the testimony that we're hearing really is just a little bit irrelevant over being afraid that a person might be charged. You have to be able to prove it.
Representative Welch, you're recognized.
I think in this bill, as amended, there's two subjects here. Somebody who sexually assaults somebody and the person who gets sexually assaulted. This bill is kind of designed so the person who gets assaulted can get the medical treatment that she needs. And hopefully the sexual assaulter, the perp, gets arrested. To me, it's kind of simple. And during the period in the last term, when we dealt with this bill, I met some of these people, a couple of them who were assaulted. And they described the difficulty they had getting treatment. I think this is a no-brainer for me.
If I can just make a point for consideration. When it comes to the people who are abusive, they tend to, the psychological profiles rather consistent, that they target particular victims who they believe that they can take advantage of. Right? Sometimes it's not always necessarily a sex worker, but sex workers are particularly targeted, and the reason why is that there's a belief that because they are involved in act in and of itself that is a criminal offense, that they're less likely to report it, making the abuse and control easier. So sex workers are particularly targeted by abusive individuals. So this, there's some hope that this would reduce the frequency, or at least perhaps deter them being targeted particularly. Representative True.
Thank you, Mr. Chair. I cannot support the OTPA. There are too many gray areas in the bill. And unintended consequences. I do not see anything in this bill that will prevent somebody who has been sexually assaulted from going to the hospital and getting the treatment that they need. If they were to mention to a nurse or a doctor that they were a prostitute, I don't know what the doctors, I'm going to stop treating you. I'm going to call the police and have you arrested. I don't think so. I don't understand that scenario. One of the last people testifying brought up the very real possibility of false accusations and claiming assault so they cannot be charged with any other crime. And with the amendment, they can claim assault and not have to help the police find the perpetrator. All they need to do is make the accusation. They don't have to cooperate afterwards. They don't have to do any reports. Therefore, I don't understand what the bill is doing. I don't understand what the end result would be. And that's why I can't support it. Thank you, Mr. Chair.
Representative Klein Knight.
Thank you. I'm sorry that there's so much misunderstanding on this bill. This is simply a way for victims to get the help that they need. It's that simple. And I'm sorry for the people that weren't here last year to hear these are real life people. They have been denied healthcare. They have been denied services for protection, and they have been shamed. And because they're working in the shadows, and that makes them open to constantly being manipulated and abused. And if there's nobody that can lend them some help, even in the healthcare industry, we've got a major empathy problems on our hands right now. I'm going to challenge each and every one of you to please.
Representative Knight, to suggest that people lack empathy because they don't support the bill, I don't believe it's appropriate to imply that on any member, especially someone who hasn't voted on it. But even if we had, to imply that would be inappropriate.
My apologies. I meant that the intent of this bill is to allow victims to get health care without being prosecuted for sex work. It's that simple. Thank you.
Representative Swain.
Thank you, Mr. Chair. I'm going to say I will support this bill, OTBA. I have to admit I've never been in the situation of a sex worker seeking medical help, but I have been the parent of a child with disabilities. And if it makes me nervous to take my son into the emergency room because I'm afraid that they might say that I abused him to cause the break or the bruise or the cut or what have you, I can only imagine the amount of distress that somebody who was working sex might have in the thought of even going into an emergency room to seek help. And as a parent who's been through multiple times having to take my son into the emergency room and praying that they didn't think that what he did to injure himself was in any way some sort of abuse, because I wouldn't find out about that for days when I finally was contacted by authorities. It's just a distressing situation that I think that we can probably put an end to.
Representative Burke.
Thank you, Mr. Chairman. I guess I'm extremely confused now. I'm reading this bill and I don't see much about, healthcare in here. I see where, they can go to the hospital. Well, I don't even mention the hospital, but it just says, if they are abused, that they can reach out and tell law enforcement. And if I'm wrong, I would like somebody to explain, yes, I'm wrong. Tell me that the bill is about people that are abused. And it's not just women. I wish people would stop saying just women. Because guys get abused too. Tell me that this is truly for the victim, not just for healthcare.
Representative Burt, so I believe on for the underlying bill, it discusses some healthcare options. I believe starting on line 15, but it's, I don't agree that it's limited just to getting healthcare. That I believe would be at the option of the person making the report. It's really to report reporting the violent crime. It's really basically getting a person that's been sexually assaulted into a safe environment. You know, whether that involves them getting healthcare or not, I don't think it's material that they get healthcare in order to invoke this.
Okay.
But that is an option. The problem is that, not the same problem, but the concern that the amendment resolved was that federal law will not permit the option of getting the healthcare and the immunity side contingent on getting the healthcare. You needed to separate that requirement of cooperation. That's apparently a federal law. That's just based on the testimony. So the amendment clarified that federal law conflict that I haven't independently verified that, but that's what the testimony was.
Yes.
So it's healthcare is part of this, but it's not the end all be all.
All right. Thank you, Mr. Chairman.
Does anyone wish to speak that has not been recognized already? It's within the chair's discretion to only recognize members to speak a single time when it's been open to Representative Bolden. You've already been recognized. So at this point, seeing no hands raised from any members who haven't spoken already, the matter will now be put to question. If you're in favor of the motion about to pass as amended, please say yay. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Welch,
Aye.
Representative Burt,
Yes.
Representative Spillane,
Yes.
Representative Green,
No.
Representative Wallace,
Yes.
Representative Testerman,
No.
Representative True,
Nay.
Representative Pratt,
Yes.
Representative Marston.
Nay.
The clerk votes yes. Representative Harry Gathright,
Yes.
Representative Bixby,
Yes.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
Chair votes yes.
Mr. Chair, the vote is 17 yay, 4 nay.
Almost made it to consent. By a vote of 17 yeas and 4 nays, the motion about to pass as amended is passed.
Chair.
Successful outcome.
Information that I had gotten from the House leadership earlier is that there actually is no hard and fast rule as to when it can go on consent. Before object to consent, it can still be put on consent. Because it can be removed by any member at any time. There's no hard and fast three vote rule. You can say without objection, and then if somebody that has voted objects, then it would not go on consent.
Well, let's try it now. I'm going to move for consent. Is there an objection? Seeing none, this matter will be put on consent. Sure, I'll be notified if that's incorrect. At this time, we will close the executive session on House Bill 123. At this time, we are opening the executive session on House Bill 557, relative to the authority of state and county correctional facilities to discipline inmates using close or solitary confinement. The chair now recognizes Representative Wallace to make a motion.
Thank you, Mr. Chairman. I move House Bill 557 in expedient to legislate.
Is there a second to that motion? It's been seconded by Representative Pratt. Representative Wallace, do you wish to speak to your motion?
Yes, briefly. Thank you, sir. Well, the prime sponsor herself in her testimony did say that when I asked what the impetus of this bill, I wasn't really sure whether it was an old archaic language that turns out was actually amended in 1987. So it certainly isn't that old. And seeing that it also doesn't eliminate the practice, just the mention of the words, there's no need for the bill.
Representative Pressman.
He's doing real well with this bill, thinking it ought to pass the testimony of various people. But when Chelsea Manning testified, was basically stole a whole bunch of classified, got pardoned by President Obama, and thinks that being a traitor is okay, but not being in confinement. I can't support
it. Representative Muse.
I'll be supporting this bill because I think Commissioner Hanks was pretty clear that on the fact that what this bill does, and I think the sponsor was clear too, is it bans this as a form of punishment, but it doesn't ban the practice in other cases when it's necessary. I think Commissioner Hanks also said she was actually looking forward to having some of the language updated because that particular section is archaic. So I'm not sure I understand the opposition. I'll be voting for it. I'm sorry, I'll be voting against the ITL.
Seeing no further hands raised, the matter will now be put to close. Representative Boardman, recognized.
Yes, thank you, Mr. Chair. Well, at the state prison, we think that there's no real need for the bill, but that does not necessarily flow down to county jails. So I'm also going to oppose the ITL in favor for all to pass as amended. Thank you.
Representative Bolden, you recognized?
Thank you. I think that maybe there's a misunderstanding about the testimony that was given by the Commissioner of the Department of Corrections. There's an amendment that the Commissioner felt was important to move through this committee, which would give the Commissioner the authority to discipline inmates for specific reasons, such as attempting to escape or being violent. So I think that it would be wise to vote down the ITL so that we could maybe consider the amendment that was personally drafted by the Commissioner of the Department of Corrections so that she could update the existing law to reflect the current practice in the state facility. Thank you.
Okay. Representative Bolden, I just may pose a question. If I understand the difference between having the law codified and passed as opposed to the practice, but if the practice is with one policy that is not illegal, I suppose passing this bill wouldn't change how the commissioners are handling solitary confinement, correct? What you're saying?
I'm sorry, can you repeat that? There were some connection issues and I had trouble processing your words.
I'll say it again. This is basically to update the lawful practice of how solitary confinement is being used already. I suppose this isn't going to change any practice that's already in place. It's being followed by.
Yes, so there was a mention of changes recent as I think the 80s. I have some research from the research department in the State House showing that this was originally codified in the 1867. And at the time, this encompassed the entirety of interactions between corrections staff and inmates. This was really all that they needed to say about how to run a facility and how to discipline inmates. And back then, work was commonly, field work, building things. Work was a lot more involved and was far more attached, really tied to your way of making right with the community. Work was an important way to pay your dues to society. And that's not so much the nature of incarceration now. Now there's a focus on education, medication, treatment, things like that. And so the amendment that I would like to be considered.
Suspending for a moment. You answered the question. I did give you some leeway, but you weren't recognized to speak in, just to continue to advocate for an opposition to ITL. So I'm just, at this point, it's just a simple question that you've answered. I thank you for taking the question. Representative Gathright?
Just want to make sure I have this right. It did repeal county correctional facilities from using the close and solitary confinement. However, it didn't, the DLC. And I thought what was said was that they have rules in place now that speak to, solitary confinement or using the clothes. So I say that to say that part of it was, repealed. Did I get that right from what I read?
Are you asking me?
Yeah.
Do I defer that to the committee as a whole?
Okay, Amanda. Representative Bolden.
And Representative Bolden, please address the question asked by Representative Gathright.
I'm really sorry, but is it possible to phrase it in a little more concise way one more time?
Okay. Did the amendment repeal the county correctional facility from using closed or solitary confinement? Yes.
The answer is sort of yes. It's just that the amendment doesn't address that portion of the existing bill. So the bill has 3 sections. The first section addresses the state facility. The second section addresses county facilities. And the third section just dictates when the bill would take effect if passed into law. And the second section addresses the county, repeals the portion that allows the county.
Please, for a moment. That was as close to a yes or no question as we'll ever have, which you did answer the question. We just, to let you go on, we can't recognize someone to speak a second time unless all the people who wish to speak have raised their hand. So if you're going beyond the back and discussion like that, it's not appropriate. Representative Bigsby.
Yes, thank you. So the way that I'm reading the amendment is that the amendment replaces the entire first section of the bill, and that rather than just changing the language, what the amendment seems to do is set forth a modernized approach to how discipline is handled by the corrections department. And that would be essentially replacing what was previously set out as the way that discipline was done. And that what the amendment does is essentially sets in statute the authority for the Commissioner of Corrections to make rules that are following modern best practices for discipline. So it seems like with the amendment, I could support this this bill. And the section 2, I think has been discussed, is just getting rid of what is really an archaic thing that's not needed at the county level. Thank you.
Seeing no further hands raised. Oh, excuse me.
I want to address the difference between the state prison and the jails, and perhaps Representative Wallace will follow along with me. In the jails, we have two sections. Those people who are convicted and serving their short sentences, and we have the people awaiting trial. The people awaiting trial could be anything from murderers to rapists, you name it, and you can't make them work. So I think just repealing this section in the county correctional business is not a good idea.
Correct.
Now, what the commissioner has said about her state prison, that's good. But why are we eliminating the authority of the county correctional facilities? We have 10 jails, 10 sections of the state. The people who are arrested, they're all different kinds. And it's a very dangerous place in the county jail, even more so than the state prison. So I think if we're going to pass this, we should re-amend it and take out section 2. That's my view. I can't.
I just.
I have to recognize Representative Splain. I'm really sorry on this. Representative Splain.
Thank you, Mr. Chair. I have to agree with the Vice Chair. And my biggest problem with this bill from the beginning, even looking at the amended version, has been the complete and total repeal of section 30-B:7. And I actually looked it up to find out how much was actually being repealed by that statement. And it's essentially one paragraph that says discipline of inmates. Now, this was created in 1988. It's not archaic and it's not very long ago. It says if any inmate in a county correction facility is refractory and stubborn and refuses to work or perform his work in a proper manner, the superintendent may put him in close confinement until he submits to perform his task and obey the superintendent's orders. It's as simple as that. And if we take that out, that to me means that we have removed one method of controlling the inmates who are unruly at the county level. And we know that the county inmates do work. We see them out doing work jobs. Oftentimes it's voluntary and they get asked if they want to, but I'm not going to get involved in the micromanagement of that, and I don't believe we should either.
Seeing no. Yes, the motion is an IPL, so.
I still just have a question. So section 2 exists today, correct? That's not something that just got here, right? Repeal on the
That's what I just read,
on the
section
original
2.
bill.
That repeals current statute.
Yeah, but that was already there. I mean, that's not new.
No.
Correct.
That was on the original bill.
Okay.
And there was no testimony on it, that I know of.
Representative Newman, you're recognized.
Thank you, Mr. Chair. I think when we get into the discussion of micromanagement and bills and what should be taken out and what should be left in, it was always my opinion that you don't necessarily have to make all the rules and regulations that a prison would run by passing legislation to ensure that solitary confinement is appropriately administered. And I think based on the testimony that I thought I heard, was that the commissioner also said that they have close confinement and other terms for what in effect is de facto solitary confinement. And those rules are described, and I think even at the end of this bill, it might say they will be appropriate, the best practices appropriately described in regulations or something to that nature, because I'm not looking at the bill because I can't do Zoom in that at the same time. But that's my opinion on whether or not, and I'm going to vote yes for this bill. Thank you, Mr. Chairman.
Seeing no hands raised, I'm going to question. If I can call the roll. If you're in favor of the motion of inexpedient to legislate, please say yea. If you're opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burke,
Yes.
Representative Spillane,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yay.
the clerk votes yes. Representative Harry Gathright,
No.
Representative Bixby,
No.
Representative O'Hearn,
No.
Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman,
Unmute.
No.
Representative Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman.
The chair votes yes.
Mr. Chair, the vote is 11 yay, 10 nay.
By a vote of 11 yeas and 10 days, the motion of inexpedient to legislate is passed. President Walsh, would there be a majority report? President Bolden, would you be carrying the minority report?
Sure.
This time, we will now close the executive session of House Bill 557. At this time, we will now open the executive session of House Bill 539 relative to records of communications of common carriers. Representative Kessler, do you wish to be recognized to make a motion of ought to pass?
I make a motion of ought to pass for Bill 539.
Is there a second to that?
I'll second.
That motion has been seconded by Representative Spillane. Representative Kessler, do you wish to speak to your motion?
Initially, I wasn't really into GP this one, but the more I looked into it, it actually requires the government to do what they ought to do. And that is ask authorities into your private information. I'm not even sure they ought to be there then, but at least this gets them out of just making a phone call and having somebody drop it off on the desk the next day.
I don't think so.
I think
lazy for that.
A good first step in limiting some of their ability to get into your private information. So I'm in favor of it.
You will now open the matter for discussion. Representative Muse, you're recognized.
Yes, thank you. I'm going to oppose the motion ought to pass. I really do wish we would have had a little more expert testimony in this case. We didn't hear from anybody in the carriers regarding the carriers. The Attorney General's office wasn't available to tell us what their position was on this particular issue. I'm aware of the fact that there is case law out there that actually does require search warrants in some states to be obtained in cases like this. But I'm just very wary of adding something like this to our statute without really thoroughly vetting it. And I don't really feel like we did that today. I thought we got off to a good start. But to me, this is a classic example of a bill I think we should be looking at a little bit closer. Thank you.
So one point that I would make is, and I do agree with Representative Testman that I had some concerns about this bill when I first read it. What I was looking at here is that it's one thing for the Attorney General or law enforcement to request information from any communication company carriers, right? From a cell phone company, they can request it. But the law is written, they really sort of have to comply with it as long as there's some reason to, as long as the AG says that we have reason to believe that there's information on there that will help us in an investigation. I was under the belief that the law would allow them the option to comply, but they don't have to. The fact that they don't really have much of an option of not complying, in my opinion, if it's not a Fourth Amendment violation, it's very close. So I'm surprised if it's not, if it's a voluntary surrender, just like a voluntary search. You can agree to provide said information all you want, but it doesn't seem that it's necessarily voluntary here. Now, I understand that that's just if a cell phone provider wanted to not cooperate, and really some of these, they take pride on protecting their privacy of their customers. So I'm going to support the motion about to pass. Seeing no hands raised, Representative Marshall.
Thank you, Mr. Chairman. I just want to point out, during testimony, I was very surprised by Attorney Penny Dean, who, at the beginning of her testimony, I thought she was going to be opposed to this bill. And in the final analysis, she was telling us she supported it. And that was strong for me.
Representative Walz.
Thank you, Mr. Chairman. I too initially was somewhat opposed to the bill, thinking it had to do with metadata and whatnot, but as we peel back the layers of the onion, it seems like this particular bill does do quite a bit of good to strengthen the privacy rights of New Hampshire citizens, and I'll be supporting the bill.
Seeing no hands raised, the matter will now be put to question. If you support the motion about to pass, please say yay. If you are opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burt,
Yes.
Representative Spillane,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yay.
the clerk votes yes. Representative Harry Caffrey,
Nay.
Representative Bixby,
No.
Representative O'Hearn,
No.
Representative Bourdonnais,
Yes.
Representative Muse,
Should know.
Was it no?
Representative Newman,
No.
Representative Bolden,
No.
Representative Conley,
Yes.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman.
The chair votes yes.
Mr. Chairman, the vote is 13 yea, 8 nay.
Got a vote of 13 yeas and 8 nays. The motion of ought to pass is passed. Representative Peston, will you be preparing a majority report?
Yes.
Will there be a minority report? Representative Muse?
It's a constitution. It'd be interesting to see who writes a minority report.
That's a yes.
Yes.
At this time, we now close the executive session on House Bill 539.
Mr. Chairman?
Representative Wall.
Yeah, just a statement. I just heard back from Superintendent Henry at the Rockingham County Jail. And I know we've already settled the previous bill, but in response to the question on the county level, His words to me in response to removing the ability to use closer solitary confinement was, we still need to be able to use the solitary confinement for inmates who are not violent, who are violent or will not behave. Solitary confinement could also be used for medical issues as the need to keep separate. Depends on how it's worded. So
There you go.
couldn't get back to me in time. It was out to.
That's okay.
5:39
Representative School.
and second. First,
Oh, Representative Casterman made the motion. Representative Spillane seconded it.
At this time, we're now going to open the executive session on House Bill 546 relative to 911 immunity for reporting that a person has been a victim of a violent crime.
Excuse me, what number?
Oh, sorry, 546. Chair now recognizes Representative Rhodes to make a motion about the pass.
Thank you, Chairman. Make a motion to pass for House Bill 546.
Is there a second to that motion?
Second.
That motion is seconded by Representative Welch. Representative Rhodes, wish to speak to your motion.
Mr. Chairman, I think we've heard all that there was to say about it from the testimony. I don't have anything more to add.
The matter will now be open for discussion. Seeing no hands raised, the matter will now be put to question. If you're in support of the motion about to pass, please say yay. If you're opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burt,
No.
Representative Spillane,
Yes.
Representative Green,
No.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Nay.
Representative Pratt,
No.
Representative Marston.
Nay.
The clerk votes yes. Representative Harry Gathright,
yes.
Representative Bixby,
Yes.
Representative O'Hearn,
Yes.
Representative Bordenay,
Yes.
Representative Hughes,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
The chair votes yes.
Mr. Chairman, the vote is 16 yay, 5 nay.
By a vote of 16 yeas and 5 nays, the motion about to pass has passed. Will there be a majority report?
Told you.
Representative Bolden, would you wish to prepare?
Sure.
Representative Burr, you prepare a minority report?
No.
Will it be a minority report?
Unless one of the others, I don't care if it goes on consent, to be honest.
I don't like to reach my bill, so I couldn't write it ever before.
I'm not opposed to consent.
Okay.
Not opposed.
Move to consent.
I'm sorry, can you just want to make the majority report?
Representative Bolden, who has her hand raised as well, is going to make the majority report.
Representative Bolden must be recognized.
Representative Bolden, you have a question?
I will phrase this as a question. Do you know if a bill has a fiscal note, if it can go on consent?
That's a good question.
That is a fantastic question. The answer is no, cannot go on consent. And let me guess. So that would also apply to HB 123.
It doesn't have a.
But when it has the issue of the fiscal note, is that something that we as a committee and this is a parliamentary inquiry to the vice chair. Because the fiscal note, we don't consider the fiscal note, I mean, we, obviously that's took that into consideration, that's not something that.
No, I think the fiscal note estimated increase or decrease in $0 all the way across.
That's correct. So that's really not fiscal note.
That's the fiscal note.
That means somebody requested a fiscal analysis and it said nothing.
Yeah.
Can I be recognized?
Well, you're not recognized. Representative Bixby?
Yes, on the fiscal note, the amount of the fiscal note matters in terms of whether it can go on consent. And I'd want to double check with the clerk on this, but I think that if the amount is under 10,000, then it can go on consent.
I think it's rule 35, maybe rule 37.
Sounds right. Yeah.
It's all zero.
So it's all zero. So that can go on. We'll put, so I'll move for consent if the clerk, I will consult with the clerk as a precaution, just to make sure we're doing things the proper way. If we, I see a lot of hands raised, I will say that if we don't answer, I don't answer a million questions, we could actually exec more bills. So, are they parliamentary inquiries?
I have a question of the clerk. Who seconded the motion to not to pass?
Thank you, can I just put that away?
Thank you.
HB 546 is now on consent. We'll now close the executive session on House Bill 546. This time, we will open the executive session on House Bill 612, relative to the penalty for overtaking a school bus. Representative Burt, you are recognized for a motion.
Yes, thank you, Mr. Chairman. I would like to make a motion of ITL.
Representative Marston.
I'll second.
It's been seconded by Representative Marston. Representative Burt, do you wish to speak to your motion?
Yes, Mr. Chairman, just very briefly, from the testimony I hear that our current laws are working somewhat, people still, we could pass 5,000 laws, people are still going to do it. But here, this bill takes control away from the may suspend license to shall suspend license. And I really disapprove of that. I think the person in charge of doing that should have the authority because, sadly, mistakes happen. I hope with those mistakes, nothing, no children get hurt or accidents happen, but, there needs to be a leeway of control there, and this bill takes a lot of control away from people, dealing with these people that pass school buses. And that's it.
Representative Conley, you're recognized.
Thank you, Mr. Chairman. I've had the benefit of hearing this bill a number of times, serving on transportation last term, and have heard testimony that we did not hear today. Although it was alluded to by the prime sponsor, there is a real lack of clarity for judges on how to proceed with second offenses. Although we know that there aren't that many of them, when they do come, the may versus shall is effectively a default to not going to suspend a license. They default to not taking that step. This clarifies that for the court, essentially clarifies what's going to happen. And the other thing I would remind the committee is, although there are very few cases where the second offenses are prosecuted, we heard from the sergeant that that does not reflect what's actually happening with the number of times this is occurring. This bill has been, vexed transportation last term. It is something that I struggled with around the license suspension, but mistakes do happen, and that's where the first offense comes in. The second offense, I think, requires something broader. So I'll be voting against the idea.
Seeing no further hands raised, the matter will now be put to question. If you're in support of the motion of inexpedient to legislate, please say yay. If you are opposed, please say nay. The clerk will now call the roll.
Chairman, just a real quick, I just noticed we have an amendment on that. Did we discuss that amendment at all? Was that something you-
An amendment can only be introduced on a positive motion, so it's.
I'm sorry.
Well, it's an inexpedient to legislate.
Vice Chairman Welch,
Aye.
Representative Burt,
Yes.
Representative Spillane,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harriet Gathright,
Nay.
Representative Cantalakis, I'm sorry, Representative Bixby,
No.
Representative O'Hearn,
No.
Representative Bourdonnais,
Yes.
Representative Muse,
No.
Representative Newman,
No.
Representative Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman.
Chair votes yes.
Mr. Chairman, the vote is 12 yay, 9 nay.
By a vote of 12 yeas and 9 yeas, the motion of inexpedient to legislate is passed. Representative Burt, will you be preparing a majority report?
I will be doing a majority report. I just did that.
It saved ourselves $155,000.
Will there be a minority report?
That's my majority report.
Thank you, Representative Conley. At this time, we will now close the executive session on House Bill 612. So, in regard, we started out, just so everyone knows, with 59 bills. We've now completed the public hearing on all 59 of those. We have one outstanding executive session that we're not going to do today. The calendar, we are scheduled for tomorrow. We're not going to meet tomorrow. There's no need for us to meet for one executive session. There will be a reconsideration on House Bill 408. So I believe we're gonna, I'll let everyone know the exact date once I'll email the committee. We do have House Bill 632, yes.
Wasn't sure if we wanted to do that.
No, that needs to be just some further research we need to be done on that. Also, there was a House Bill 205 was retained. There was an amendment that was prepared that may be reconsidered as well. So, and eventually there'll be some second committee sign-up bills, but we don't need to. We haven't got those yet. So, for purposes of tomorrow, we're going to cancel tomorrow's hearing that was scheduled for 10 a.m. I will email the members of the committee once I learn when that next available date would be. We are